Good morning, everyone. Hi. I see some people entering. We'll just make a start now. Good morning. Well, let's get right into it. We have three guests who are going to be talking on the issue of EU rule of law and sanctions today. We've got some great speakers. I will just get straight to them. With the events in the last week, or a couple of weeks, it's been in the news about Europe's response to, say, the crisis in Ukraine, for instance, and a lot of this has been discussing the issue of sanctions. The EU has a limited number of policy tools to be able to deal with issues like this, and one of the policy tools it has is economic sanctions, particularly because of its economic power. And this raised questions which also relate to the topic of today's conference, the rule of law. And we also saw yesterday in a lot of the panels the issue of rule of law and sanctions being raised. So this is a timely and important topic, and we have presentations today on issues such as effective judicial protection, sanctions and jurisdiction, as well as issues of bypassing listing procedures, and we'll have a discussion about those. Our first speaker is Luis Hinojosa Martinez, professor and chair of international law and international relations at Granada University, and formerly a president of our European Society of International Law. He will be talking today about the rule of law and effective judicial protection versus raison d'etat in the EU's policy sanctions. And let's get straight to it. I'll give you the floor.
Thank you very much. For obvious reasons, I will skip the part where I thank the organizers for having invited me to this conference. And in any case, I would like to say that I am very glad to share this panel with Janek Novak and Martina Di Gaetano. And I am also very grateful to Jet Odemat for having accepted to chair this panel. On the website presentation of the conference, we explained that a state's foreign policy fits poorly with the notion of the rule of law, even in the most advanced democracies, as it's the case of the European Union, since in this area, it's traditionally considered that executives must have a greater margin of discretion, a greater margin of appreciation, a quick capacity of response to defend their national interests, their geostrategic objectives. And as we saw yesterday, this dialectical tension between the mechanisms protecting the rule of law and foreign policy has been transferred to the European Union, which reproduces these tensions as a global actor, as a true global actor. So this panel focuses on sanctions or restrictive measures, as they are called technically in the language of the European Union. And in this field, we find a perfect test for the application of the rule of law in the external actions of the European Union in its classic meaning, which is fundamental rights of every citizen, of every individual vis-à-vis the state, or vis-à-vis the public authorities, or in our case, vis-à-vis the European Union. In the framework of the Common Foreign and Security Policy, the Court of Justice of the European Union has found numerous cases that violated the two main components of the rule of law, the right of defense and the right to effective judicial protection. So the main questions that I wanted to answer when I prepared my paper for this conference were more or less the following. Is the interpretation of the rule of law by the European Court of Justice limiting the Union's ability to maneuver as a global political actor? Should we consider any prejudice to the effectiveness of this foreign policy a necessary price to pay for the defense of the Union's inalienable values? Is there any room for the use of the notion of raison d'etat to defend the EU's security and strategic interests in its external relations? Could this raison d'etat introduce nuances, introduce limitations to the judicial protection of individuals against restrictive measures? Well, to answer these questions, let me remind you briefly that Article 215 of the Treaty on the Functioning of the European Union distinguishes between two types of sanctions in the context of the common foreign and security policy. Those designed to interrupt or reduce economic and financial relations with third countries, paragraph 1, and restrictive measures against natural or legal persons and groups, paragraph 2. And in both cases, the sanctions adopted must include the necessary provisions on legal safeguards. That is, among other things, obviously, they must respect the right to effective judicial protection. On this basis, the European Union differentiates between geographical sanctions and thematic sanctions. As you all know, sanctions of geographic nature, also known as political sanctions, relate to problems occurring in a particular country and seek to influence the conduct of that state or of the parties involved in conflict taking place in that state. And on the other hand, thematic sanctions that target any person or entity involved in a particular activity that the European Union intends to discourage or intends to prosecute, regardless of where that activity takes place. Traditionally, the European Court of Justice has clearly distinguished the content of the right to effective judicial protection depending on the paragraph of Article 215 that we are looking at. In the sanctions against states, in the Bosphorus case, the court held, and I quote, any measure imposing sanctions has by definition consequences which affect the right to property and the freedom to pursue a trade or business, thereby causing harm to persons who are in no way responsible for the situation which led to the adoption of the sanctions. All of this is justified under the umbrella of the need to safeguard international peace and security without it being necessary to assess the specific circumstances of each individual concern. So if your ship is seized, if your plane or your business is seized, just because you have the wrong nationality, bad luck. There is nothing that you can complain about. Moreover, the Council enjoys a wide discretion in determining the scope and nature of these measures. By contrast, when restrictive measures are adopted against natural or legal persons, the Court of Justice maintains a very protective stance and has developed a case law that enhances the right to effective judicial protection. These principles first found their way in the field of the counterterrorism through the emblematic saga of the Cadiz judgments. But however, the court has in recent years extended the same language to other thematic sanctions and even to geographical sanctions when they have an individual scope, and that's almost always the case now. So in all these areas, the Court of Justice notes that Article 47 of the EU Charter of Fundamental Rights requires that, and again I quote, the courts of the European Union ensure that the decision which affects that person or entity concerned individually is taken on a sufficiently solid factual basis. And that entails that judicial review must ensure that at least one of the reasons deemed sufficient in itself to support that decision is substantiated. This radical difference between the requirements to justify the sanctions in Article 215, depending on whether they are adopted on the basis of its first paragraph, interruption of economic and financial relations with a third country, or the second paragraph, restrictive measures against natural or legal persons, this radical difference generates tensions, inconsistent scenarios, because the same measure may be compatible or incompatible with fundamental rights depending on the wording of the sanctioning rule. So the General Court has tried to fill this gap between the first and second paragraphs of Article 215 in the case Iran Transfer, interpreting that when geographical sanctions are specifically directed to individuals or legal persons, these restrictions are subject to, literally, I'm quoting, substantially identical jurisdictional control to that exercised by the court in sanctions related to terrorism. The European Court of Justice has explicitly confirmed this interpretation in the context of the political sanctions. For example, in case Safaniku Sepahan, in the context of the sanctions against Iran. Last year, for example, in the Burudi case, the General Court annulled the sanctions against the former deputy head of the Atomic Energy Organization of Iran because he presented a letter saying that he no longer worked there. And the Council did not provide evidence proving that he continued to be an asset for Iran's nuclear program. Equally, some months ago, the General Court annulled the sanctions against Aisha al-Qaddafi because the Council had not proved that she continued to pose a threat to the stability and security of Libya 6 years after the death of her father. This case law has been applauded by many human rights activists, but let me say that it is very controversial, at least I see it as a controversial case law, because it involves a huge challenge for the European institutions and the member states, which is difficult to achieve in practice. Taking into account the large number of persons included in the European sanctions lists. Furthermore, you must take into account the circumstances in which some of this evidence has to be obtained, because these circumstances are really problematic, often in regimes openly at odds with the European Union, sometimes in places where it's very difficult to obtain information, such as in war zones. So this has compelled the Court of Justice to go back, to look for a middle ground, for a middle paragraph between the two mentioned paragraphs of Article 215, sanctions against the states, sanctions against individuals. My main point today is that the requirement that the person subject to restrictive measures must have carried out an individual act for which there is evidence that provides a solid factual basis, blurs, or even disappears, and becomes a mere formalism in the context of some political sanctions. And this has been allowed by the European Court of Justice through several jurisdictional techniques that I will now briefly summarize for you. First, the establishment of general sectoral sanctions that affect a category of individuals in the sanctioned country regardless of their personal conduct. For example, in the Bank Melak saga of judgments, the Court of Justice established that the measures affecting a group of individuals, a sector of private activity, in this case it was the Iranian financial institutions, must be judged by the overall effects that such measures may have on the activity to be discouraged, in this case the financing of nuclear proliferation, and can be justified without taking into account the individual conduct of each affected bank, which, it said, is not relevant. The second technique, or the second instrument that makes it possible to include specific individuals in the sanctions lists without having to provide evidence of their behavior, is the establishment of legal presumptions. The European Court of Justice has accepted that the European authorities do not have to prove that state enterprise or a company whose majority shareholder is the state generate income for such state. That can be presumed. In the context of purely private business activities, the European Court of Justice considers it compatible with the rule of law that companies could be sanctioned because of their strategic character for the third state. So the fact that any company likely to provide support to a government on which you want to exert pressure could be subject to sanctions have been described in another case by the complainant, the national Iranian oil company, NIOC, as contrary to the values of freedom and the rule of law. That's what they said. Because they said this would allow restrictive measures of individual scope to be taken against any Iranian taxpayer, any Iranian official. However, the European judge interpreted that only support that due to its, I quote, quantitative or qualitative importance, end of the quote, could contribute to the development of nuclear activities was punishable. I have to say that this nuance, quantitative or qualitative importance, was not found in the European norm. So it was an intelligent trick, pulling a rabbit out of the hat by the court that allowed it to justify the legality of the measures, the proportionality of the measures. In the same vein, the European Court of Justice has gone so far as to hold that the designation of persons merely on the ground that they are prominent businessmen operating in Syria is lawful, without it being necessary, of course, to prove that those individuals benefit from or support the regime. And this is based on the assumption that the Syrian regime exercises a strong control over its economy and the court establishes the presumption that it's only possible to enjoy a significant business status in Syria if you maintain close links with the regime, as Bani case. So what I've just said provides a solid coverage for the new sanctions adopted against strategic industries or leading business persons, providing a substantial source of revenue, as the new norm says, to the Russian government. And I anticipate little chances of success in the potential appeals of the oligarchs that they have already announced against these measures. Third technique. A third factor of justification could be leveled as a sympathetic evaluation of evidence presented by the European institutions to justify designations. So given the difficulties in obtaining proof in the international and, as I have said, often hostile environment in which they are gathered, the court has a sympathetic evaluation of this evidence. For example, in the Badika case related to restrictive measures against the Central African Republic in the illicit diamond trade, the General Court considered as sufficient evidence the data collected by the Security Council Committee, which provided some circumstantial evidence, so not direct evidence of diamond trading by the sanctioned company's personnel, and some witness testimonies that did not include the names of the witnesses. And the General Court justified the weakness of this evidence by the fact that they have been obtained in a civil war situation. And that's fair enough. So a fourth element that allows considerably widening the group of persons who can be subject to individual restrictive measures is what I've called a flexible characterization of these persons as associated with other designated persons. Let me put an example in an area that is delicate because of its relevance to freedom of expression. The Kiselev case. The General Court considered that the exercise of journalistic activity by a person appointed by the government, in this case personally by Vladimir Putin, as head of the Russian Federal State News Agency to carry out propaganda that contributes to destabilizing another country, in this case Ukraine, may justify his designation, even if this entails a restriction to freedom of expression. Another example of ample flexibility is the Sharif University case. Here, the Court of Justice said that the fact that as a consequence of the designation criteria, a large number of civilians alien to the activity to be discouraged are affected does not violate the principle of proportionality, as long as the inclusion in the list of sanctions of an entity to which they are related is justified. This was the case, for example, when restrictive measures are taken against a university which, with the consequent harm to the majority of its faculty and students who are not involved, obviously, in any objectionable activity, but this university develops a research program for the Iranian army. So, as a conclusion, I would like to stress that this jurisprudence of the Court of Justice places it among the judicial bodies with the greatest capacity to control executive activity in this area of international policy, and as a champion of the right to judicial protection in a field which third countries enjoy much greater discretion to pursue their strategic objectives. However, beyond the declarations of principle on the rule of law, on the right to effective judicial protection, the Court of Justice has allowed realpolitik to find some open doors to enable the European Union to defend its interests and its values with strength, with forcefulness. In particular, in the context of geographic sanctions, when the European Union seeks to influence the conduct of a third state, the requirement that the person targeted by restrictive measures has carried out an act of individual scope for which there is evidence providing a solid factual basis disappears in some cases and becomes a mere formalism. However, and I finish, to the extent that the criteria for designation become more concrete and more personalized and come closer to the scope of what could be a criminal or administrative sanction, the exigency of precision in the motivation and correlative evidence increases, and the possibilities of annulment rise if the European institutions have not respected the rights of the designated person. In an international context, this complex construction of the Court of Justice has placed the European Union at the forefront in the protection of fundamental rights of individuals subject to sanctions. Thank you.
Thank you for that presentation, going over quite a lot of the case law as well of the Court of Justice of the European Union, which also links to the next presentation, which is also focused on sanctions cases. And I pass the floor over to Dr. Yannick Novak from, he's an associate at De Bant in Brussels, and also works as a visiting lecturer in EU and international legal systems at Innsbruck in Austria. He has degrees from, a PhD from the University of Leuven and degrees from King's College and University of Antwerp, and knows quite a bit about the Court of Justice as well and procedural law. But I'll hand it over to you. You have the floor.
Well, thank you very much, Jed, for this very kind introduction. I will speak about the jurisdiction of the Court of Justice in the area of the common and foreign security policy. So it's a bit broader than just sanctions, but of course sanctions are the main subject matter of the court's jurisdiction in that area. So what is my presentation about? Well, pre-Lisbon, of course, we had this idea that jurisdiction of the Court of Justice was an exception in the area of the common and foreign security policy. Now, with Lisbon, as we all know, this has changed, and 3 points are evident of that. First, we have the importance of the rule of law now also in the common foreign and security policy, because integrated in the EU, and the rule of law as a founding value of the EU, so also affects very strongly the area of the common and foreign security policy, as we also have heard already throughout the presentations. The court's approach, Article 19 of the TEU, basically gives it general jurisdiction throughout the whole of the EU's policy areas, including the common foreign and security policy. And this has led to a kind of expansionary reading, basically, of the court's jurisdiction in that very area, which has been subject to quite some criticism in the literature, because it deviated from basically the pre-Lisbon idea that the court's jurisdiction is limited. and that for certain instances no jurisdictions were basically conferred expressly by the treaties. And so this made me think, because I'm also a procedural lawyer, that this is kind of akin basically to inherent jurisdiction basically. The court says, look, I have jurisdiction because I am the court of the EU, I have to basically uphold the rule of law, and therefore I can exercise jurisdiction regardless of whether an express conferral exists in the treaties. I'm not the first one that has argued that. We have the article of Arnold from 1990 in the Common Market Law Review, but this basically proposition was then thereafter left entirely unexplored, and so I try to bring it back here. So the idea of jurisdiction without an express conferral, the idea of the court having jurisdiction because it is a court, it is inherent in its nature, and then of course the question, how does this sit with the principle of conferral, basically, which structures the division of powers between the EU and the member states. Now, briefly, it's important basically to unpack this notion of inherent jurisdiction because it's used quite often in different places, but what is its exact meaning? Well, the first thing is it is of a substantive nature. So it's about basically a court being able to hear actions or remedies that have not been provided for in a statutory element. And it's basically so different from inherent powers, because as we've seen in the common law, where this theory doctrine originates, that basically inherent powers is about the procedure and controlling procedure once you have jurisdiction. And inherent jurisdiction is not just about, for example, making sure that briefs are submitted in time, etc. It's basically inherent power. So here, inherent jurisdiction, it is about substantive jurisdiction. The origin, of course, lies in the English legal system, in the common law and equity courts, basically, that were a direct emanation of the sovereign in a way, and therefore they also had these powers basically that existed as an emanation of the sovereign. Then basically in 1873 these powers of these courts that existed were transferred basically to the High Court. And so the idea then exists that basically the High Court has inherent jurisdiction that comes basically from the historical powers of these common law and equity courts, and that the High Court can exercise that jurisdiction when basically statutory instruments do not provide for necessary procedures, actions, or remedies. So that's the idea. Now, in common law doctrine, there's then the idea, well, basically it was transferred to the High Courts, so only the High Courts of England, but also Ireland, etc., they have inherent jurisdiction, so it's not for other courts. Courts that are called statutory courts, which powers have been conferred upon them by statute, they do not have inherent jurisdiction. Now, this is, of course, contested, because you can see that practice is different, and also you see many other courts that are of a statutory nature also exercising inherent jurisdiction. Now, what is precisely the content of inherent jurisdiction? Well, wardship, so over children or incapacitated, I put it here because it sort of strengthens the idea that this jurisdiction originates in the sovereign as the parens patria. So the sovereign takes care of these incapacitated through the courts, and then judicial review, content of court, but not procedural issues. But you always have to be careful with these lists of courts. And then also important to understand, inherent jurisdiction is not unlimited. Basically, it doesn't give the courts the power to do whatever they can do, because it's clear that when express statutory limitations are provided, the courts cannot surpass those. So when jurisdiction is taken away by statute, well, it is taken away basically. And then also for the exercise of it, there should be a degree of necessity as well, as appears from practice. Now, inherent jurisdiction also exists in international law, and the European Court, International Court of Justice in the nuclear test case, quote, so the court possesses an inherent jurisdiction, enabling it to take such action as may be required, on the one hand, to ensure that the exercise of its jurisdiction over the merits, if and when established, shall not be frustrated, and on the other hand, to provide for the orderly settlement of all matters in dispute. Now, what appears from this is that, in principle, inherent jurisdiction is here approached as a procedural power. And so you see that there's confusion again about the notions that here basically inherent jurisdiction is more a kind of inherent powers to protect the procedure once jurisdiction has been established. I think only in the Lagrange case inherent jurisdiction has been exercised in a way that is close to proper inherent jurisdiction, that remedies could be provided regardless what had been provided for. Now, so inherent jurisdiction, I argue for my paper, I approached like this. So a court has jurisdiction because it has a court, and so it's about the nature of a court, and it has been said to have this kind of metaphysical origin because it is in the confines of history that it emerged, and it's not actually clear how it emerged, apart from that it's connected to the sovereign, basically. So this sort of is indeed this metaphysical origin. It's about substantive jurisdiction, so not procedural. I say it's also statutory courts, but to a more limited nature in a way. So within the basically the function of that court can basically exercise inherent jurisdiction. And of course there are limits, the statutory limits and limits because out of necessity. So this is the framework. Then I've tried to look at the court's case law in the area of the common and foreign security policy through that framework to see basically whether the court, how it basically approaches its jurisdiction, is not an approach that is inspired by a concept of inherent jurisdiction. Now, if you look for traces, you will certainly find it. And most important one is already the general approach of the court regarding its jurisdiction in the CFSP. And so in Parliament versus Council on the agreement with Mauritius, basically the court sort of makes clear that Article 19 is the basis of everything, and that the area of the common and foreign security policy is exceptional. So the final sentence of the second subparagraph of Article 24(1), as well as the first paragraph of 275 TFEU, introduce a derogation from the general rule of jurisdiction which Article 19 confers on the court, etc., etc. Now, it is interesting to see that how the court takes this approach further. So we have then the decision, the judgment in H versus Council, which was basically about a judicial review of a decision of a head of mission of the Kosovo mission to redeploy a member of personnel to another regional office, which brought proceedings against that decision. Now, generally, does it fall on Article 24, 275? That is debated and was debated, but the court said, look, the fact that this is basically such a decision within the area of the common foreign security policy does not necessarily exclude jurisdiction of the court. And the court criticized, but it took up jurisdiction and decided the case. And so what transpires from this general approach basically is when there is doubt, well, then there is jurisdiction for the court, even if it was very doubtful in H versus Council. But since it was not completely clear, expressly clear, that jurisdiction had been taken away from the court, basically the court said, look, we have jurisdiction. And this corresponds truly with this inherent jurisdiction approach. When it's not taken away, well, then we have jurisdiction. So doubt is always in favor of the court's jurisdiction, basically. And we see also in Rosneft. So Rosneft, well, the case has been brought up a couple of times, so it's just going to go directly to what was the question. The question was, does the court have jurisdiction to give preliminary rulings on the validity of restrictive measures, both in respect of Article 40 of the TEU or Article 275 of the TFEU. Article 40, silent on the procedure. Article 275 only mentions the action for annulment. And so then the question is the court restricted to that? The court said, no, I have jurisdiction for preliminary references in this matter. And with Article 40, well, there is silence. And again, an inherent jurisdiction approach, silence does not mean exclusion, so the court took it up. Bit more controversial, Article 275, because their jurisdiction was there said to be limited to actions for annulment. But looking at that from an inherent jurisdiction perspective, you also cannot find an express limitation in there. there is doubt, the court sort of played around with the doubt and basically accepted jurisdiction. And if you run through basically this idea of inherent jurisdiction, so locating its power in more, let's say, vague metaphysical way, that the rule of law, etc., that is as in general jurisdiction for judicial review vis-à-vis EU acts, then no express limitation can be found in the treaties. There is no provision that says court is prevented from exercising plenary ruling jurisdiction, and the court also advances reasons of necessity. So when approaching that case from a inherent jurisdiction perspective, it actually makes perfectly sense. And the same we see in the case of Bank Rifa Karagan. There, basically the question was whether the court has jurisdiction to hear an action for damages in relation to restrictive measures. Now, this takes the matter even further, because while in Article 275 you could find a sort of connecting factor with judicial review, this was actually largely absent in this respect. But again, and it becomes actually fairly simple, the approach, if you follow it, and so we must always be careful when things are simple, but for now I believe it has explanatory value. The court again situates its power basically to award damages in its general power, not even for judicial review, but to provide judicial protection for EU acts. Of course, again, the links with the rule of law. We also see, again, no express limitation anywhere in the treaties, and the court also provides a necessity argument, so overcoming this lacuna. So again, the court takes up jurisdiction. And then a last case here to illustrate the point. It's probably the case that some of us triggered to submit an abstract to this conference, so quite a few people might know this case very well. Now, what I want to, so the question, are third countries legal persons for the purpose of Article 263(4), so they can bring an action for annulment in the EU courts in respect of restrictive measures? I want to focus on the rejection of the reciprocity argument that was advanced by the Council and a number of member states. The court saying, look, the obligations of the European Union to ensure respect for the rule of law cannot in any way be made subject to the condition of reciprocity as regards relations between the European Union and third states. So you see this idea, and you also found that in CADI already, basically that the court's jurisdiction cannot be limited per se by international law, doctrines, rules, customs, etc. And so here you could also apply basically, you say, look, well, there is no express statutory limitation or limitation in the treaties, and because like in CADI, the court works from the treaties. But then there is also case law from the Canadian Supreme Court that says, look, the limits on inherent jurisdiction have to be in line with the rule of law. And here the court clearly says, look, limiting our jurisdiction here would not be in line with the rule of law. And what is interesting with the case, that it links the whole story up also with the autonomy of the EU legal order, that basically, and it resembles CADI in a way, that basically protection of the jurisdiction of the Court of Justice is necessary for the autonomy of the EU legal order, something that also basically is, well, transpires from Opinion 213 on the accession of the EU to the European Convention on Human Rights. Now, this is, of course, all in the area of the common and foreign and security policy. There are also traces of that beyond the area of the common and foreign security policy. Here we all know the Lever case, where the court said, look, basically an action for annulment is not specifically foreseen against the European Parliament, but nevertheless, rule of law, judicial protection, we're going to allow it. So one of the first cases of inherent jurisdiction. More recently in Simpson, NHG versus the Council, the court accepted that an objection of illegality could be brought, raised also against an act of individual application, whereas the treaties only provide for an objection of illegality vis-à-vis an act of general application. There again, you could apply the same reasoning. It was not excluded expressly either, and therefore the court could take it up. interesting, I found, is the case of Commission versus Poland regarding the forest in a place I cannot pronounce in spite of what my name would suggest. Basically, the Polish government started to have some forest operation management in a forest which is of particular value. The Commission brought an infringement action against Poland because it would be in violation inter alia of the Habitats Directive. The interim measure, the Commission also applied for interim measures, first ex parte, they were granted, and then there was discussion afterwards in a contradictory manner on the interim measures, but the Commission had found that Poland had not complied with the ex parte order, and so it supplemented its application with a request that the court would also lay down penalty payments for vis-à-vis Poland for having not respected the interim order or not respected the final interim order. And it's interesting to approach that from inherent jurisdiction and then from one of the ways it can be exercised, namely the contempt of court, because penalty payments, financial sanctions, only available basically to the court as a matter in a final judgment under the infringement procedure 258 or Article 262 and 3. But the court here said basically, look, I have the power to award these penalty payments in order to protect the effectiveness of my interim order. And this sort of reflects an idea of contempt of courts, and which is actually an exercise of inherent jurisdiction, well, a primary example of that. Of course, it's not just about expanding or inventing or providing new ways, it's also about limits. And one of the prime examples you find in the Unión de Pequeños Agricultores case, where the court said, look, the predecessor of Article 263 specifically expressly limits jurisdiction in respect of actions for annulment, and so I cannot surpass that limitation on my jurisdiction, even not on account of effective judicial protection. So it also works the other way around these limits. Now, some final considerations. So what you see here, what transpires, of course, is that the rule of law is behind this. It's the common thread throughout this case law, as also was already argued yesterday by colleagues from the Usher Institute. And it's interesting because this rule of law is a founding value of the EU, but the court also sees in its source of jurisdiction. Article 19 is an expression of Article 2, basically. The court considers its jurisdiction also to be at the foundation of the European Union. And you could say basically that's also the reason why the court exists. It's to uphold this rule of law. And so if you would tie it together, basically what emanates from that is that the court considers that it has jurisdiction because it is the court of the European Union. And so this sort of, from that transpires an idea of jurisdiction. I have jurisdiction because I am the court, and which is sort of reminiscent of Spinoza. In its Ethica, so the endeavor wherewith everything endeavors to persist in its own being is nothing else but the actual essence of the thing in question. So the court has jurisdiction basically because it is the court. It is of course not absolute. There are limits set by the inherent jurisdiction doctrine, and then we also of course have a number of limits that are derived from the EU's constitutional setup. You will see that it only works vis-à-vis EU acts, and you also will see in the case law the court also tries to sort of find the nature of its inherent jurisdiction still in the treaties, from Article 263 action for annulment or Article 267 premier rulings for the validity. It sort of distills from that it has a power of judicial review, and then sort of is going to exercise it also in areas where it has not been provided expressly. The same for the action for damages, etc. So there you still see that the court tries to be more or less in line with the principle of conferral, but it interprets it in a way that is consistent with the rule of law. And so therefore my idea is that the court has inherent jurisdiction, but is of course functional in a way that it is to sort of, perform its role as a court of the European Union. so that it will, of course, not trespass that and start reviewing national measures. So it's not that type of inherent jurisdiction. So it is limited and I think compatible with the principle of conferral. It is an interpretation of the principle of conferral in line with the rule of law as a founding value of the European Union, and therefore I believe the court as inherent jurisdiction in a functional matter, and I believe this is a good approach to the court's jurisdiction and far more than the more of strict approach to the principle of conferral and the court's jurisdiction that you can still see in some of the literature. I thank you for your attention.
Thank you, Yannick. We now have someone, it's online, right? We have the next presentation. I can already introduce.
Okay. Whenever you're ready, we are. Martina.
I'll just briefly introduce beforehand, just so I don't want to have all the echoes and everything, but our next presenter, talking about delisting procedures through informal debanking and defunding practices, is affiliated with the University of Maastricht. Martina de Gaetano is a researcher affiliated with the Reclaim, working on the Reclaim project, who has experience in policy and legal analysis, academic research, and EU project management. And I will now pass over the online floor to you. Do I need to? Please, go ahead.
Okay, thank you. I hope you can all hear me properly. I will now share my screen and a brief presentation that I've prepared. So, please let me know in case there are any issues with that. Okay, can you all see full screen my presentation?
And we see you as well.
Okay, great.
Perfect.
That's great. So you have both things at the same way. Okay, so first, thank you to the organizer of this conference. As it was previously mentioned, I will be addressing now some unintended consequences of the decentralization of implementation of counterterrorism financing legislation, particularly as regards the impact that the banking and the funding practices may have on the non-for-profit sector. To do so, I will first address the phenomenon of the banking and the funding, since it's not so well known as a phenomenon. Then I will address the research questions that led my research and my paper, and then I will be performing two comparability tests and one compliance test. The first two to compare listing procedures with the phenomenon of the banking. The second comparing the financial regulation procedure to suspend funds and the practice of the funding. And the third comparing the respect of fair trial guarantees by listing procedures, the financial regulation and customer due diligence checks. And I will then conclude with some takeaways and recommendations. As regards the phenomenon of the banking and the funding, it must first be outlined that what the risking is. So the risking can be defined, as you can see, as the phenomenon that financial institutions and banks may adopt to terminate or restrict business relationship with specific clients, with specific class of clients, in order to avoid rather than manage risk. In practice, it means that specifically the NPO sector, so non-for-profit and NGOs, may face limited access to basic banking services due to the cost and the risk that financial institutions may have to face in accepting them as clients. This is a complex phenomenon. There are many factors that may be considered as drivers, so I will not attempt to provide a full overview of such drivers. However, it shall be understood as an unintended consequences of poor decentralized implementation of counterterrorism financing measures. Why counterterrorism financing measures? Mainly because financial institutions as decentralized actors have a duty to perform customer due diligence checks when they are onboarding new clients, and they are also obliged to perform ongoing checks. In practice, this means that they need to identify the prospective customer and its beneficial owner, and they need to have a full understanding of the nature of the customer's activity. In addition, as I was saying, financial institutions also have an obligation to perform ongoing checks. Such customer due diligence checks are normally performed by relying on privately owned profiling companies' database that allow financial institutions to perform screening checks. However, access to the license of such companies is expensive, and each check cost represents a big cost for the financial institutions. This means that financial institutions may decide not to accept a client, specifically when it is a non-for-profit organization, due to the cost that they may have during the whole business relationship compared to the benefit they may have from accepting that NPO as a client. In practice, what does it mean? It means that NPOs may face limited access to basic financial services, both when they are attempting to open a bank account, when they are performing their banking relationship, and ultimately when they decide to end a banking relationship. In practice, this means that they may face delay or block of funds, but also freezing of existing accounts. So, taking this as a context, I have tried to reply to this research question. So first, I've tried to see whether CTF centralized practices, notably listing procedures, can be compared to decentralized practices as I have just explained. So to the practice of freezing bank accounts or freezing assets due to the risking practices by financial institutions. In addition, once verified whether they are comparable, I tried to see whether such centralized and decentralized practices achieve the same level of safeguard or fair trial guarantees. And once ascertained that they do not, I tried to see to what extent it is possible to bring CTF decentralized practices under the same umbrella of EU procedural guarantees in order to ensure the same level of safeguard of the right to fair trial. As to the comparability test, I will address this very quickly. In the two tables that you see in this slide and in the following ones are mainly aimed at showing you that both listing procedures and customer due diligence checks as concerned this slide may achieve the same result, notably delaying or blocking funds transfer, restricting access to basic banking services, and even freezing existing accounts or leading to the closure of bank accounts. So since they both can achieve similar results, I consider them as needed to achieve also the same level of safeguard of fair trial guarantees. The same can be said as regard the financial regulation and informal and private sector related practice of the funding. Here I will explain a bit more what I mean. So in the financial regulation, we can find a procedure that requires the commission authorizing officer to suspend in a provisional way or to deny funds or to exclude from the awarding procedure all those entities and natural persons that can be considered connected to terrorism supporting or money laundering. In this case, then, what the entity or natural person may face is ultimately the exclusion from being awarded EU funds. Similar effects can also be achieved by the private sector in a less formal way. So it is still a case-by-case analysis of the specific situation, but private foundations and donors may ask their grantees, so normally NGOs or NPOs, to perform the same screening and vetting checks that financial institutions are required under the anti-money laundering and counter-financing terrorism legislation. However, grantees are not always able to perform the same kind of checks due to the expensiveness of such checks or due to the nature of their activities. In this case, they may experience similar effect as those foreseen in the financial regulation, notably the temporary suspension of funds pending internal investigations within their donors, or they may be denied access to funds or the renewal of financial supports. In addition, it is now emerging a trend within EU institutions where there are informal investigations ongoing on the basis of allegations submitted by third countries' authorities that may lead to the same kind of funding practices without, although respecting the same guarantees as provided in the financial regulation. In particular, those guarantees that I refer to as fair trial guarantees can mainly be summarized as the obligation for EU institutions to state reasons and rely on verifiable evidence, the obligation to disclose such evidence, and on the side of the defendant, the respect and the right to enjoy the adversarial principle and the right to access to an independent and impartial tribunal. I will now briefly assess whether listing procedures, the procedure in the financial regulation and the banking procedures ensure a comparable level of respect of fair trial guarantees as referred to in the previous slide. So as concerned listing procedures, EU institutions have in general within the EU sanction system a general obligation to balance confidentiality and security concerns with the individual or entity fundamental rights. This can be further explained and has been further addressed by the court in its case law on sanctions, and it can be summarized by reference to the obligation to state reasons, the use of reliable evidence, and the rights of the defense. As concerns first the obligation to state reasons, according to the court, EU institutions are obliged to state in a clear and unequivocal manner the reasons on which they adopted a specific legal act, and this is particularly true when such acts have an adverse effect on individuals. In addition, the court also clarified that this right needs to be balanced, this obligation for institution and right for the defendant needs to be balanced with the objective of the act. This means that the court will perform a balancing exercise to ensure that on the one side the individual has access to sufficient information to challenge the adverse decision, while at the same time ensuring the effectiveness of the act of the restrictive measure in this case. Similarly, in the case of the rights of the defense, the individual has the right to be immediately informed about any adverse decision, and this right to information also comprises access to the grounds on which the decision has been adopted and the evidence adopted in its support. The defendant also has the right to intervene, among other ways, by submitting additional information and asking for the review of the case. In doing so, EU institutions cannot rely on any kind of evidence or information. While there is no specific principle in EU law as regards the need to rely on specific kind of evidence, the court has said in its case law that EU institutions always need to provide a set of indicia sufficiently specific, precise, and consistent. This is connected on the one side to the principle of the unfettered adduction of evidence, which allow parties to provide any kind of evidence in support of their allegation, but at the same time it allows the court to evaluate case by case whether the evidence submitted are sufficient to substantiate the allegation. In this regard, the court will particularly check whether facts are accurate, there is no manifest error of assessment or misuse or misinterpretation of the facts. In addition, and this is particularly relevant for the case at hand, in case of press and newspaper articles, the court only allows them as corroborative evidence. Similarly, in the financial regulation, we can find a comparable level of respect of fair trial guarantees. So in the context of the procedure on exclusion, suspension, or reduction of funds, where the European Commission authorizing officer evaluates the situation and eventually decide for an adverse decision against the concerned entity or individual, the authorizing officer has the obligation to state reasons. Additionally, he needs to rely on specific information, such as final judgments or administrative decisions, or facts established by EU institutions, bodies, or agencies, such as EPO, OLAF, or the Court of Auditors. Finally, he can rely on facts as referred to by member states or third country authorities. However, he cannot, as you can see, rely only on newspaper articles or press releases, as already said with regard to the listing procedure. Finally, as for the rights of the defense properly intended, as previously said, the person or entity concerned needs to be informed of the preliminary and final decisions adopted against him and has a right to know about the grounds, the evidence in support of the decision, and the deadline to submit additional information or to make use of the legal remedies at its disposal to challenge such adverse decision. Differently, in the context of customer due diligence checks, we cannot really find the same level of respect of fair trial guarantees. First, as you can see, there is no obligation on the financial institution side to state the reasons behind their decisions. So they have a general obligation to refer to, well, a kind of reason on the basis of their decision, but it's normally a general reference to the lack of interest in conducting business relationship. This is also connected to the fact that the relationship between financial institutions and NPOs is normally of a contractual nature, so they are not obliged to enter in business relationship with an NPO. Conversely, due to the non-disclosure agreement that financial institutions are obliged to sign with profiling companies providing screening database, usually they are obliged to not disclose sources and content as produced in the context of the checks performed by the screening software. In addition, they do not have any specific threshold to consider evidence reliable. So normally they rely, as I was saying, on privately developed and owned software, which can only collect publicly available information. This means that, in essence, those software are made upon publicly available criminal records when they are available and newspaper articles. So this is a first very big difference compared to listing procedures and the financial regulation procedures. And this is particularly concerning in all those cases, in all those third countries where the freedom of the press is not properly ensured and newspaper can easily be manipulated and be the source of disinformation campaigns and piloted abusive lawsuits. Finally, as concerned the rights to be informed and intervene, so the rights of the defense, financial institutions cannot really ensure this right to the extent that they cannot disclose information about the sources and the content and evidence they relied upon. And in addition, they may limit their information obligation to a general letter saying that the bank is not willing anymore to conduct business relationship. From what has been said, we can draw a first conclusion that is then, of course, that customer due diligence checks do not ensure a similar level of respect of fair trial guarantees as listing procedures and the financial regulation. And this despite the fact that in the end they produce and they may have a very similar impact on the daily conduct of activities of NPOs. This can be explained by referring to many different drivers, and here I have tried to summarize them in the four that I consider the most relevant ones. First, there is a lack of uniform regulation and guidelines for both financial institutions and profiling companies as concerned the performance on screening procedure. And this means that, in essence, both financial institutions and profiling companies rely and have to refer to a broad set of different regulatory systems, both at the European, national, and international level. This creates a system of legal uncertainty and insecurity that, in the end, leads to very differentiated treatments in different jurisdictions. This is also connected to the fact that there is a generalized lack of clear standards as to the reliability that evidence needs to reach to be considered reliable, and the lack of trained personnel within financial institutions that have specific expertise on the peculiarities of the non-profit sector. And finally, and this is more connected to the EU level, there is a general lack of recognition of NPOs' rights, particularly as regards access to basic banking services. From this, I will quickly conclude. As we have seen, centralized practices such as listing procedures and financial regulation procedures as concerned limited access to EU funds exist, and they allow for a stronger respect of fair trial guarantees. However, as you may have studied and know, they are frequently very long and burdensome. So this is the main reason why decentralized practices have been developed, especially in the context of the Anti-Money Laundering Directive. They exist and they need to remain in place, since they are the only kind of procedures that actually allow for a quick intervention at the local level. However, such decentralized practices reaches the same kind of impact on the individuals and entities as centralized ones. So they need to ensure the same level of respect of fair trial guarantees. I've tried here to respond to the how question, which was not exactly the easiest one to reply to. And I've come to the conclusion that a first needed step is the analysis by EU institutions of the unintended negative effects of the incorrect implementation of EU counterterrorism financing legislation. In addition to these, both EU institutions and member states should develop at the EU and international level consistent and coherent standards that profiling companies and financial institutions need to follow when performing screening procedures. And finally, they both need to rely and refer to formal procedures for investigations in order to, on the one side, set in a clear way the rights to access documents and intervene in the context of the procedure, and ensure a minimum level of reliability for evidence to be considered in the context of the procedure and to take decision. So I have now concluded. We'll come back to my screen, and thank you for listening, and I'm open to any questions you may have.
Thank you for the presentation. And everyone perfectly on time, amazing. I also encourage those who are online to add your questions to the chat as well. I think they have precedent, right, to be able to have questions on the chat. We do have one already. I can start off with an online question from Graham Butler asking about a question on your presentation, asking about the recent KS case which is being appealed, and has a broad question about CFSP matters other than restrictive measures and staff cases. Do you think that the court will still have jurisdiction in events like that, outside of those cases, such as missions in third states? So I think it's a question about how far your ideas go towards kind of this overcoming this exception.
Yes, so I don't know the details. We're not going to circle around it. I don't know the details of the case as such, but the question is clear. I think the court might push it very far. I think it will be, unless the court is absolutely certain it can be established that jurisdiction has been taken away from it, I believe that the court will, even though contested, but the court will try basically to establish jurisdiction. That is, if you look at it from the perspective I've taken of a union jurisdiction, that is basically the logical consequence. So I think this can go even much further, because indeed of what we've been talking about here, about the rule of law and interpreting the court jurisdiction and also the conferral principle in line with the value that underpins the union. So it might go broader. I can't tell you why, because I don't have a, but yes would be my answer, for sure.
Did you have anything to add on that question as well? No. We'll now go to the questions here. I think the first one you had your hand up was Ramses, and yeah, can you go first? Yeah, and we'll take a couple of questions. Yep. You just need the microphone. No, back here, back here.
Thanks very much. Thanks, Jed, and thanks very much to the three presenters. All very interesting presentations. And I have two questions, and both of them to Louise and Yannick. And let me start with the last one, because it links up very well to the question that Graham just posed. And in fact, it may be the same question, so I can also push you a bit further, Yannick, on that point. Because I very much like this idea that you present of this inherent jurisdiction. I wish I came up with the term myself, because it's actually what many of us have claimed over the past few years, right? That the court is not so much extending or stretching its jurisdiction, it's basically using the options that were already given in the treaty. Yet you could argue that what the court has done is basically not dealing with CFSP cases. They were all these cases that you mentioned were basically in the context of CFSP. So they were dealing with either staff matters or public procurement or something else, or access to documents, where the court actually always said, well listen, if I can decide on access to document in any field, I can also decide on access to documents in CFSP. If I can decide on staff matters in any other field, I can also do it in CFSP. So the argument is then, I'm not saying that I agree, but I want your reaction. The argument is then, it has not really been about CFSP yet. And CFSP, the real CFSP, is really excluded by the treaty. That's something that the Council has come up with a number of times before the court. So your reaction on that, it's a bit similar as Graham's question. Can I just also do Louise's, or yeah, just to save a bit of time? Otherwise I will be speaking again. So on Louise also, thanks very much. Really enjoyed your presentation, and perhaps to push you a little bit further to take a stance here, because listening to you about the EU being a champion of judicial protection, you can read that both ways. You say, oh, okay, look how excellent they're doing their job. But also keeping in mind your remarks of yesterday, you can also read this as they're going too far. Because by providing such an extensive judicial protection, they're no longer allowed to live up to the obligations under international law. So I finally want to know where you stand on this point, if you see my question.
Who has a microphone? Just behind you as well.
Thank you very much. Thank you very much. Can you hear me? Okay. Well, I don't want to push anyone because I'm not so authoritative as Ramses, but just put a question to Janek concerning the inherent jurisdiction. Well, I enjoyed a lot your presentation, very clear, very well organized, but as an international, public international lawyer, it is not really clear to me. What's your opinion on the nature of inherent jurisdiction? Because indeed, as you said, when we use the term of art inherent, so this means inherent to the very nature of a court as a court of law, which is why it's inherent. So this is a justification which is a non-justification. But of course, it is more complicated if we look at international adjudication, broadly understood, because in that case we have a jurisdiction which is based on the consent of states. And so, for example, from the standpoint of the International Court of Justice, so there you have a series of legal views. There are also a series of opinions which are contained in separate opinions of judges at the International Court of Justice. And for example, in that case, generally it is said that inherent powers should be justified on the basis of a norm of general international law in the form of a custom or of a general principle of law, and depending on also on the kind of inherent power. And so I just wonder whether it is possible to really justify inherent jurisdiction in the context of the EU legal order and so on, as regards the jurisdiction of the Court of Justice of the European Union. Thank you very much.
I will take questions from everyone who has their hand up, but you were also third, Wolfgang, and then we'll do another round.
Yeah, thank you, Wolfgang Maas, University of Speyer. My question relates as well to Jan Novak's presentation. First of all, well, it doesn't come as a surprise if one observes the approach of the Court of Justice to exceptions in particular to its jurisdiction, but we find also other exceptions in the treaties relating to fundamental freedoms and so on. So the approach usually is to construe exceptions narrowly. So we find that as well. So, but the idea and notion of inherent jurisdiction, of course, is a concept which helps us understanding this and gives it additional legitimacy. But still the question is the approach of the court consistent? Because you said, well, a limitation to this concept and notion of inherent jurisdiction is an explicit rule in the constitutional rules, for example. And when you look to this Portuguese agriculturist case, the court still construed narrowly this exception of who can stand and bring a case under 263 paragraph 4 direct effect, and so we see, well, here the court does not enlarge its jurisdiction. This is still construed narrowly, and this is somehow not very consistent. But then the question is, where can we find the rule for this? Why does the court behave it in that way? So it's not in line with this idea of inherent jurisdiction. And the second question, very briefly, the Venezuela case, you addressed that there might be some rules and principles of international law affected. Well, if a foreign state goes to a domestic court and does so because he presents a case as a plaintiff, as a complainant, then of course the state voluntarily submits to the jurisdiction of the domestic court of another state, and this, well, it's done by consent, so it's not an international legal issue, or isn't it? Am I wrong?
Right. Shall I? Quite some questions to take. So if I go back to Rams's question. Yeah, well, I think my answer will be pretty similar as the one I gave to Graham. Is basically that, well, in this idea of inherent jurisdiction, this idea of express limitations taking away the jurisdiction, basically. So I would say in principle the court has jurisdiction unless taken away by, well, express treaty provisions. What you also see is that the express intent, but absolutely clear, of the legislature. So it depends, of course, the court how it interprets it, because I will come back also, this links up with the question, the last question. It depends, of course, on how the court constructs it, is it has been expressly excluded or not. But so I don't see, when the treaties are clearly saying, look, this is where you should not go, that the court will and should then also accept it, because that is basically what is part of this whole idea of inherent jurisdiction. Of course, it is also the court who interprets, of course, its jurisdiction, and so there we might still have basically debates. So I'm not saying that the concept of inherent jurisdiction will not basically lead not to, will basically solve all debates, but I think it's as an approach, and because it exists already also outside of EU law as something developed, it allows us basically to more carefully analyze and then also criticize the court perhaps from a more fundamental perspective, that, for example, in the H versus Council, we now have the discussion, is it an operational decision, is it the management? And then, yeah, well, you can stand on both sides there, where, for example, but I think with inherent jurisdiction, because it also can actually function as an outsider perspective, you have a more structured way of addressing that. But it's certainly not without limitations, and so when it's clearly from the treaties, this is where the court should not go, then yes, that inherent jurisdiction would also say, look, you cannot go there. So I hope that answered your question. Then the second one from the, yes, well, the nature of inherent jurisdiction, if you look at the literature in the common law, it's, yes, it's somewhere, it's somewhere there, it's unclear, so they trace it back to the common law courts and the chancery courts pre the Judicature Acts, and that basically emanates from the sovereign. So it has a kind of metaphysical origin, as also has been said in the literature. I could say the rule of law might be as a value, perhaps now for the Court of Justice, a better justification, but there again, the rule of law as a value, it comes back to the last point, is the court who interprets it. So does it's more, will it limit basically the court? That's the question, but it allows us to understand better basically how the court reasons. Also in a system that it's based on conferral basically. But yeah, again, it's the court in the end who is the source, but also of its own power basically, because it will decide on how far it goes. And yeah, so from that perspective, I believe there is this kind of inherent jurisdiction as well, because it is the court that will decide on its own jurisdiction, and I see inherent jurisdiction here as substantive and not as procedure, whereas this is different, I believe, in international courts and tribunal, where inherent jurisdiction is mostly used for powers to control process, make sure it's not frustrated, that there's no abuse, but not to hear, for example, actions that have not been consented to be given to it. So there I see the difference. But again, it's a concept. I try to use it to explain. You're, of course, more than welcome to disagree, of course. The next question, first about the UPA case. Well, the UPA case, I found it interesting because I never really read it like that before, but the court that explicitly says, look, here the treaty provisions basically have expressly excluded. So this word expressly to me has a particular meaning in light of this jurisdiction. And again, yes, you could say, look, this is of course the court playing with words and sort of justifying it, but what is, yeah, why had it said it in that way? But it is consistent if you would look at it from inherent jurisdiction, that the court there interprets, and it's again the court, of course, policing the borders of its own power, so that will always be the problem here, because you could always say, well, court Article 263 does not expressly limit that, or you could overcome that if you would want that. But if the court perceives this as an express limitation on its jurisdiction, yes, then there is no jurisdiction, and in line with this theory of this doctrine, or whatever you call it, of inherent jurisdiction, if the express limitation is there, well, then the court has to refrain from accepting jurisdiction. And then with the Venezuela case, well, yeah, there were different arguments advanced by the by the Council and the member states. One of them was of submission. I didn't find that very particularly strong in order for then the court as an argument to reject. So that's why I focused solely on reciprocity as this idea, because it's only one things the court takes up explicitly. That look, reciprocity, all well, but there is the rule of law, and therefore we go for the rule of law as our founding value, and we're not gonna sort of follow this reciprocity argument. Yes, but yeah, I hope that also answers your question. Thank you very much.
Okay. Yeah, thank you. I'll answer to Ramses' question. It was about, well, the EU is a champion of the right of effective judicial protection, but is that prejudicing its role, geostrategic role as a global actor? Well, if you want to push me forward, then what I have to say is that yes, I think that the change in the case law, when it extended the same principles to the geographic sanctions, the terrorist, the right to judicial protection in the context of terrorist sanctions, when it extended that to the political sanctions, it went too far. But as I have said, the court went back. 5 years ago, these nuances made by the court have made that the Council now wins 2/3 of the cases. Before that, the Council used to lose between 70% and 80% of the cases. So the problem is the wording. The wording is key. If the sanctioning norm says that you are sanctioned for very specific reasons, you've got to provide evidence that you have fulfilled those things. But if the wording is very general, and you say that you provide support, material support to the state, then the obligations of the European institutions are much looser and easy to comply with. So the question is how you draft the sanctioning norm. And now they have learned to do it. Let me put a case which is which provides the right example of how this works. So in the Bank Melat cases, all the Iranian financial companies were sanctioned. And that was fair for the court, because they said it is the overall effect of the measure on the financing of the atomic programs of Iran. So it is proportionate. But in the case of Sina Bank, which was an Iranian bank that was whose shareholder was the Mostazah Foundation, directed by the Supreme Guide of the Iranian Revolution, that's the head of state. The sanctions were annulled because, as this bank was controlled by a foundation controlled by the state, it was accused, it was sanctioned because it provided direct financing to the nuclear program. So, as the Council did not provide evidence of a specific financing of the nuclear program, the sanctions were annulled. So the bank that was more related to the nuclear program could not be sanctioned. And that was because of the wording of the sanctioning rule, because it was under a different heading. So, to answer your question, the court went too far, but it has gone back, and for example, now the sanctions against Russia, I think that they have a solid basis, solid legal basis, because of this change in the case law that I've tried to explain. That's it. Thanks.
No, I think it's enough. I totally share what was said by my colleagues.
Do we have time for just another round of questions if there's some? I know we're already over.
We are over, but
we're
this is
already
the last one.
Or you can use the coffee break to have a chance to approach our panelists. And I think we should join and thank.
Good morning to everyone, and sorry for this slight delay. Is due to technical problems. I know that there was a second person online, so I was looking for someone else in this round table. I have missed one person, but it's fine now. So it is my pleasure to share this round table with you. I guess that when the directors of this international congress organized this event and set up the final program of it along 2021, and even if an important tension was already present between Russia and Ukraine, they didn't expect, as any of us, that things would reach this point. So today I'm very much indebted to them for having invited me to moderate precisely this roundtable. Thank you very much. Last Wednesday, after the Russian Federation lost the voting rights either on the delegation before the Parliamentary Assembly of the Council of Europe and the permanent representation's voice before the Committee of Ministers, the Russian's flag was lowered by the Council of Europe in the main building of Strasbourg. A concierge put it down and folded it. 3 members of the Russian delegation were present of the permanent representation of Russia before the Council. They were present and were waiting to receive the flag. No authorities on the side of the organization were present. The flag, once lowered and folded, was taken inside the building by the concierge. The 3 representatives left the place with empty hands. This was the way of dishonoring one government that had so widely ignored and attacked the rule of law principle. This role has appeared in different ways along this Congress, I'm sure, but now it is precisely time to address the cornerstone role of the rule of law principle beyond the EU, particularly in its enlargement to the East, something that, which seemed to be one of the sins committed by Ukraine, or at least one of the propaganda reasoning used by Russian Federation. They wish to join also the European Union, apart from NATO, obviously. So this crucial value and condition for belonging to the EU has become a central condition in the new European Commission's enlargement strategy for Western Balkans. It's much more than what can come immediately through our minds. Independence of the judiciary, for example, something very much fought even before the European Court of Justice, as we've seen in the case of Hungary or Poland. This is about fighting organized crime and corruption at the very heart, of what has been called stabilocracies. In some countries engaged in this enlargement dialogue with the European Union's Commission, which have so far failed to show any true political will to strengthen the rule of law, as it contradicts, obviously, the interests of many of those autocrats in power. So in line with the many enriching and in-depth reflections made by the previous colleagues participating in the previous round table, we can wonder, for instance, about Montenegro welcoming and hosting of some of the most luxury yachts owned by Russian oligarchs these days, taking into account the supposed will to join the European Union, escaping precisely from EU sanctions. So to reflect on these matters, I'm honored to share this roundtable with these most distinguished colleagues. In the first place, in order to approach the EU rule of law obligations in third countries and the impact assessment perspective, we count on Elizabeth Reed-Cairo, here present in the room. She holds a double master's degree in law and management from the Universidad Autónoma de Madrid. During her studies, she undertook several internships in some important Spanish law firms, such as Garrigues and Uría Menéndez, in the area of Spanish and European competition law. She also holds an LLM in European law from the College of Bruges. Elizabeth worked as an academic assistant at the College of Europe during the academic year 2014-2015, and she joined the Centre d'études juridiques européennes in September 2015, where she is currently a PhD candidate. She assists the courses on the external action of the European Union and on the law of internal market of the European Union also. She is one of the coaches to the European law model competition too, so it's a hard task that. Thank you so much, Elizabeth. The presentation is shared with another colleague, so I just briefly introduce him also, and I'll give you the floor, because her colleague is online, I think, is attending online to the event. Luigi Leonardo, who is a graduate teaching assistant at the World Studies Department, King's College London, and a teaching assistant at the Paris School of International Affairs at Sciences Po. He holds also a LLM in EU law from King's College London and a law degree from the University of Bologna. He has attended summer schools and courses in international politics at the London School of Economics, the University of Cambridge, and the École Nationale de l'Administration in Paris. Before starting his PhD, he interned at the international law firm Hogan Lovells LLP at Milano, and during his PhD, he interned at the London-based NGO, the Equal Rights Trust. So, taking into account that Luigi is online, Elizabeth, the floor is yours. Thank you so much.
Thank you very much for the introduction, and thank you again to the organizers of this workshop for this event that we are all, I think, enjoying very much. The presentation that I will do today refers to the paper that I've written with Luigi Leonardo, who is indeed joining us online, and I will do the presentation, but he will later on also participate in the discussion with all of you. Our paper looks at the effects of the promotion of the rule of law in the EU neighborhood. The question arose because when we were doing our preliminary research for when we saw the call for papers, we saw that there were quite a lot of literature on the concept of the rule of law in the EU external action, on the instruments used by the European Union to promote the rule of law, or on the role of EU institutions in the promotion of the rule of law abroad. However, there was not so much literature on the actual impact that EU actions were having in the third countries concerned. So one thing is what are the expected results of EU instruments to promote the rule of law, and the other is what are the actual effects and whether the rule of law situation improves in third countries thanks to the actions undertaken by the European Union. The concept of the rule of law in the EU external action has already been largely discussed during the previous panel, so we won't insist on that. But for the sake of clarity, in the EU neighborhood, the European Union especially focuses on three aspects of the rule of law. One is democracy and free and fair elections. The second one is the fight against corruption. And the third one is the independence of the judiciary. Considering these objectives, the European Union uses a variety of instruments to promote the rule of law abroad. Professor Wessel already yesterday discussed a little bit that these instruments could be categorized depending on whether they were multilateral, bilateral, or unilateral. However, we also think that we can categorize them depending on whether they are what we call cooperative instruments or confrontational instruments. Meaning that some instruments, the cooperative ones, look at positive incentives to promote the rule of law. such as political dialogues, financial assistance, or accession negotiations. On the other hand, there are other instruments, the ones that we call confrontational, that are more coercive. And it essentially refers to sanctions or to resolutions and statements in multilateral fora, for example, in the Human Rights Council. The European Union uses all these instruments in the promotion of the rule of law in the EU neighborhood. And in our article, we refer to several examples where actions have been undertaken. For this presentation, we will focus on 3 specific examples because they reflect the variety of approaches that are used by the European Union in the neighborhood, and therefore they allow us to assess whether some ways of promoting the rule of law might be more effective than others. These examples are Belarus, where the European Union uses, of course, a confrontational approach to promote the rule of law. The other one is the Western Balkans, where the rule of law is promoted through accession negotiations. And the third one is Tunisia, where the rule of law is promoted through the European Neighborhood Policy and financial assistance. First of all, with regard to Belarus. In Belarus, the main instrument to try to promote the rule of law in the country is through restrictive measures. In addition to restrictive measures, we have also found that the European Union is also very active in multilateral fora, especially in the Human Rights Council. All resolutions adopted at the Human Rights Council on the situation in Belarus have actually been sponsored by the European Union. And the European Union has also made repeatedly statements on the human rights situation in Belarus at the Human Rights Council. The question is therefore whether all this active role on the rule of law situation in Belarus have actually resulted in any effects at all. In this case, the answer, unfortunately, cannot be positive. Since 2020, where the presidential elections were considered as a massive fraud by the High Representative of the European Union, more than 35,000 people have been arbitrarily detained in Belarus. The former presidential candidate, Sergei Tsikhanouski, was sentenced to jail a few months ago in December 2021. And also 1 month ago, in February 2022, there was a referendum in order to bring some constitutional amendments in Belarus, but this referendum has also been considered as not improving at all the rule of law situation, both in procedural terms, in the way the referendum was handled, and also in substantive terms, in terms of the reforms that the referendum, the constitutional amendments were about to bring. Therefore, in the case of Belarus and the use of sanctions, restrictive measures, and Human Rights Council resolutions, it can be said that the European Union has essentially failed to bring any effective changes in the rule of law situation, in the rights of protesters, of political opposition, of civil society, and of the independence of the judiciary. As a second example, we use the case of Tunisia as an example of the European Union policy to promote the rule of law in the southern neighborhood. The choice of Tunisia is because after the Arab uprisings, Tunisia was considered as an exception, a positive exception, where the Jasmine Revolution had worked very well to promote democracy and a change of regime. This initial assessment has to be nuanced when we look at the longer-term effects of the reforms that were introduced. Initially, the European Union led a number of projects and reforms that indeed contributed to some initial successes. For example, the European Union was a mediator when the new constitution was being drafted, and it really played a mediation role between opposing political parties, between religious political parties and secular political parties, reaching a constitution that has been considered one of the most progressive ones of the regions. So this was a success. The European Union also had an electoral observation mission in the 2014 presidential elections, and it also led several projects with the Council of Europe, essentially, on the establishment of independent authorities and in the promotion of the independence of the judiciary. However, when we look at a longer-term assessment, as I said, the results need to be nuanced. For example, there was an organic law on a constitutional court that was adopted in Tunisia in 2015. However, now in 2022, the members of that constitutional court have actually not been appointed so far. So the constitutional court is not functioning, which of course strongly undermines the rule of law in Tunisia. In the same sense, although there was this project on the support to civil society in Tunisia, actually civil society organizations in Tunisia consider that the support of the European Union in the country has been quite limited towards them. So in this case, we can say that the results are quite limited. There have been some formal achievements, but when we looked at the implementation of the measures and the long-term effects that these reforms have had, the answer is already not that positive. The third example we wanted to present is the one on the Western Balkans. This example is obvious. The first reflection that we have is, well, for a country, the incentive of acceding to the European Union must be that strong that it should push for formal reforms and for effective reforms and for a strengthening of the rule of law. However, as was already mentioned in the introduction to the panel, this has actually not been the case, and the European Commission has repeatedly mentioned the fact that the rule of law is not improving in the region. This is despite the fact that the European Commission has progressively strengthened rule of law requirements in accession negotiations. However, the European Court of Auditors presented a report on the rule of law in the Western Balkans in January 2022, where it shows that all these regimes in the Western Balkans have progressively become more authoritarian over time. As it was the case in Tunisia, in the Western Balkans, we also find some formal reforms. So there are amendments to the constitutions that are brought. There are laws on the freedom of media, on the freedom of expression. There are high authorities for the judiciary that are established. However, their implementation is very weak, and the European institutions find repeatedly signs of the lack of judicial independence, a strong corruption in all institutions, and they link that to a very strong lack of political will to actually implement those reforms. So what the report of the European Court of Auditors shows is that as long as the European Union is present through projects in the region, these projects are undertaken and technical reforms are put in place. However, these reforms are then not sustained over time once the European Union leaves or once the project ends. So again, here, very limited results and not a very effective action. So I'm sorry because this image is not very big, but I just wanted to show an overview of the latest rule of law index in the countries that we have examined. So Belarus on the top, Tunisia in the middle, and then for the Western Balkans, I've taken Serbia, but the result is actually very similar in all the countries. What we see here is not only that the score is actually quite low, but also, I don't know if you can see it, but it has actually decreased in the 3 countries examined over the past 7 years. So what we can see is that either if we take a more confrontational approach or if we take more cooperative and positive incentives mechanisms, EU actions to promote the rule of law in the EU neighborhood do not seem to be working, which makes us wonder whether the approach of the European Union should be changed, whether the values that the European Union is trying to promote in the neighborhood should evolve somehow, or whether there is a sort of solution that can be found to actually match the expectations of all these instruments, which are indeed a lot. And as I said, it's not that the European Union is not undertaking actions, it is, but they are not providing the results expected. So I think I will stop here for now, but thank you very much for your attention, and I look forward to the discussion.
Thank you very much, Elizabeth, for being respectful with the time assigned. Thank you so much. That's easier for the moderator. Now we have online our dear colleague, Lisa Lowersy, PhD candidate at Leiden University, lecturer at the Hague University of Applied Sciences. Can we have her? Yes, sure. Thank you. Lisa Lowersy is a senior policy advisor on EU and national environmental law and policy at the province of South Holland. She read law at Utrecht University and Japanese at Leiden University. She obtained her PhD from Leiden University on the topic of the EU's conceptualization of the rule of law in EU external relations, with a particular focus on development cooperation and enlargement. Before joining the province, she worked as a senior lecturer and research coordinator for the law program at the Hague University of Applied Sciences, as well as lecturer EU law at the Europa Institute of Leiden University. And that's precisely what she's going to deal with in this next intervention. From the outside looking in, lessons learned from the EU's rule of law conceptualization in enlargement and development cooperation. So the floor is yours, Lisa. Thank you very much.
Can everybody see this or not?
Yes. Yes, we can.
Okay, perfect. Good. Well, thank you very much for your kind introduction and the invitation to speak at the conference. I have slightly adjusted the focus of my paper, and I retitled it "What Lessons Can Be Drawn from the EU's Rule of Law Conceptualization in Enlargement for its Internal Rule of Law Concept." Much has been written about the developments of the EU's internal rule of law toolbox after Barroso, then Commission President, in his State of the Union speech in 2012, remarked that the institutional mechanisms in place were not designed to adequately address the threats to the foundations on which the Union is built. Indeed, a better set of instruments would need to be developed to counter the threats to the legal and democratic fabric in some of our member states. Various mechanisms already existed to address the internal rule of law crisis in the member states, such as Article 7 and the infringement procedure. However, for the EU institutions, the deteriorating crises seem to suggest that the existing EU legal framework to effectively safeguard the rule of law internally had limitations. It does not provide the EU with the tools to satisfactorily address the rule of law in the member states. This in turn has led to a so-called rule of law instrument creation cycle, in which new periods of backsliding have resulted in renewed calls for the creation of new tools over more extensive utilization of existing ones. Consequently, since 2012, and you can see examples in the slide, new EU rule of law mechanisms have been instigated in order to try and tackle the internal rule of law crisis more convincingly. The existing literature has so far mainly concentrated on the interinstitutional battles and questions of effectiveness. To what extent does the expanding rule of law toolbox sufficiently address rule of law backsliding in member states such as Hungary, Poland and Romania? In my paper, I have looked at the issue that lies before the question of effectiveness. How do these different mechanisms the EU has at its disposal for tackling the rule of law internally inform its conceptualization of this value internally? Furthermore, the rule of law crisis mainly plays out in the newer member states. These have been on the receiving end of the EU's extensive pre-accession strategy with strict rule of law conditionality. The question then remains, to what extent lessons can be drawn from the conceptualization of the rule of law in the EU's enlargement policy in order to avoid making similar mistakes internally, aka things that have been identified as problematic externally could very well also be problematic internally. For the sake of time, I will not go into each of the internal rule of law instruments or discuss the scope of the principle therein. Instead, I will provide a brief synthesis before delving into the second part of the lessons that can be drawn from a comparison between the EU's external and internal rule of law concepts. On the basis of the analysis of rule of law elements in the EU's internal rule of law toolbox, two initial conclusions can be drawn. Firstly, overall, the EU's rule of law toolbox has provided the EU with a fairly detailed concept of the rule of law, starting with the definition of the core elements of the rule of law in the Commission's 2014 communication on the rule of law framework, which you can see in the second bullet. The definition is reproduced and even elaborated with further elements in the rule of law mechanism and the recently adopted conditionality regulation. Interestingly, however, in practice, the focus remains firmly on the functioning of the broader judicial sector and in particular on judicial independence as a recurring element. Secondly, the instruments the EU has at its disposal for the internal protection and strengthening of the rule of law interrelate and make use of each other's understanding of the rule of law. This is also reflected in the focus on particular rule of law elements throughout the toolbox. The main example of this is provided by the way the three elements of the EU Justice Scoreboard, more of them later, are also advanced under the section on the justice system in the Commission's annual rule of law reports. Turning now to the question what lessons can be drawn from a comparison between the EU's conceptualization of the rule of law in enlargement and its internal understanding of the rule of law. Two issues will be presented. First, how does the EU's approach of understanding the rule of law in measurable and quantifiable elements square with its duty to respect national variations of the member states? And secondly, the literature has identified the separation of powers as a crucial missing element of the rule of law in enlargement. To what extent has the EU's internal conceptualization incorporated this element? As it is argued in the literature, the doctrine of the rule of law allows for many national variations, as long as some basic requirements are upheld. For example, for the element of judicial review, the rule of law requires some form of judicial review of parliamentary legislation and of executive action. It does not, however, provide a form of institutional design. Differences between member states are present for various historical and political reasons. This characterization of the rule of law as being, to some extent, I call it flexible in nature, came to the fore in the academic debate on the question of the existence of European standards. For instance, regarding the element of judicial independence in enlargement. To briefly recall the discussion, the point has been made that the Commission has been heavily criticized for relying on European standards in the area of judicial independence during the accession process. The EU has articulated institutional standards of judicial governance, for example in relation to the existence of reform of the councils of the judiciary, which should be independent from the legislative and executive powers. This, despite the fact that this institutional requirement does not correspond to the legal traditions of many older member states, which have instead in place established mechanisms of judicial appointment by the executive and legislative powers. By thus promoting the establishment of independent judicial councils as one of the primary conditions for progress in the accession process, the Commission has adopted a uniform approach that has left little space for national variations. In contrast, I argue that the debate on European standards has been misguided in attempting to push the Commission to formulate detailed common standards regarding judicial independence. Since, as I said before, the concept of the rule of law does not come accompanied by fixed institutional design. Regarding the rule of law internally, in contrast to the idea of European standards, the Commission has stated repeatedly that the precise content of rule of law principles may vary at the national level, since member states have different national identities, legal systems, and traditions. This exact point was recently challenged in the context of an action for annulment instigated by Hungary against the conditionality regulation. In response to Hungary's argument that the rule of law is an abstract concept that cannot be the subject of a uniform definition in EU law and must be specifically defined by the legal systems of each member state, the court put forward a rather nuanced understanding of this issue. It pointed out that the values contained in Article 2 have been identified and are shared by the Member States. That provision constitutes an obligation as to the results to be achieved, which flows directly from the commitments undertaken by the Member States vis-à-vis each other and with regard to the EU. The Court continued that in this context it must be borne in mind that Article 2 TEU is not merely a statement of policy guidelines or intentions, but that it contains values which are given concrete expression in principles containing legally binding obligations for the Member States. Thus, even though it is apparent that from Article 4, Paragraph 2 TEU that the EU respects the national identities of the Member States inherent in their fundamental structures, such that those states enjoy a certain degree of discretion in implementing the principles of the rule of law, it in no way follows that that obligation as to the result to be achieved may vary from one Member State to another. In other words, in keeping with the flexible understanding of the rule of law, Member States have an obligation of result in ensuring the respect for the various principles of the rule of law. However, there is no prescribed, uniform, harmonized EU way in how this should be achieved. Against this background, the EU's chosen methodology of relying on measuring rule of law elements merits some attention. As I will argue below, in order to assess progress in the accession process, the EU relied heavily on quantifiable data. This methodology helped steer candidate states into a more uniform understanding of the rule of law. Within the evolution of the EU's internal rule of law toolbox, a similar tendency towards this data fixation is discernible, chiefly in the EU's justice scoreboard. The question that can then be posed is to what extent does this also lead to a more uniform interpretation of the rule of law internally, which would be counter to the duty to respect the national identities of the Member States. In relation to the accession process and its requirement of the transposition of the acquis communautaire, the Commission upholds a narrative of examining not just law in the books, but rather the rule of law in action. Aspiring Member States will need to show more than simply ticking the boxes of legal approximation. Countries must build a credible track record of reform and implementation, in particular in the area of the rule of law. However, analysis related Copenhagen documentation shows that the approach has in actual fact been mostly quantitative, with a focus on crunching data and numbers. In the light of the fact that qualitative studies on new Member States after accession and looking at the enlargement's legal approximation process talk of a world of dead letters, the argument has been advanced in the literature that measuring the outcome of law transplants in terms of quantitative implementation is an oversimplification. It cannot capture the reality of legal change. Turning now to the internal rule of law instrument of the EU Justice Scoreboard. Its data is relied on in the annual rule of law reports in order to assess progress in rule of law reform in the Member States. However, the Justice Scoreboard is not meant to provide an assessment of the effectiveness of the existing justice systems. The choice of the three rule of law elements therein, which are judicial efficiency, quality and independence, provides only very basic features and figures of a justice system. This does not mean that the chosen indicators and their data are not relevant. It does, however, highlight that the Justice Scoreboard cannot, as it stands now, be used to say anything about whether the existing justice system in any Member State is actually an effective independent one. To give an example, under the element of quality of justice systems, the scoreboard provides criteria on adequate financial and human resources. Thus, the outcome for a specific Member State on these criteria might be a high score if the justice system is well equipped with a lot of staff and has good IT resources. This outcome, however, says nothing about whether or not the judiciary actually guarantees the rule of law due to arbitrary or biased results. I argue that, at least to some extent, the Commission is mirroring its adopted enlargement approach in relation to the Justice Scoreboard. Too much emphasis is placed on quantitative criteria that do not actually provide insight into the actual functioning of certain rule of law elements. Turning back to the point of respect for national variations, it should be pointed out that the current organization of the Justice Scoreboard does not allow the Commission to take these variations sufficiently into account. To start, The presentation of separate indicators prevents the possibility of considering the interaction effects among them. As it is often pointed out, the rule of law solution chosen in one member state might not or does not have to work in another, precisely because of the interrelation between elements. The rule of law's flexible nature thus demands a more comprehensive approach. Naturally, of course, to some extent, the restricted choice of the rule of law elements in the scoreboard limits a more holistic analysis of the rule of law. As already highlighted, the scoreboard is only one source of the Commission's rule of law analysis. Nonetheless, as mentioned, the Court has called attention to the fact that the Member States have an obligation of result to ensure respect for the rule of law, while carving out space for the particular features of the legal system in each Member State, and for the discretion that each Member State enjoys in implementing the principles of the rule of law. As it stands now, however, on the basis of the data gathered by the EU Justice Scoreboard, forming a comprehensive understanding of the rule of law in the Member States is not possible. Turning now to my second point, from a positive perspective, the swift expansion of the EU's internal rule of law toolbox can be understood as a sign of broad consensus regarding the critical importance of the rule of law for the functioning of the EU. The literature has adopted a rather more pessimistic interpretation, arguing instead that the quasi-permanent new instrument creation cycle should be understood as a failure to confront those undermining the rule of law. Looking at the crisis against the background of the EU's enlargement policy, it can be said that it is not the first time that the focus has been on adjusting the process and the instruments rather than on identifying what is not working. However, instead of the common analysis, which seeks to explain the current rule of law issues not as a rule of law crisis, but rather as an autocracy crisis, arguing either for the creation of more tools or for stricter actual use of the tools already in existence, the argument advanced here is slightly different. It concentrates on the EU's conceptualization of the rule of law in terms of the missing element of the separation of powers. I argue that the rule of law should not be understood merely as judicial reform, but should also incorporate the element of the separation of powers. The EU has over the years adjusted its pre-accession strategy in relation to the rule of law, whereby fulfillment of the rule of law obligation under the Copenhagen political criteria moves from being one of the eligibility conditions for membership to advancement in the negotiations, with non-compliance a case for suspension of the process. Most recently, in 2020, building on the accession's fundamentals first strategy, the accession methodology was adjusted to incorporate the clustering of negotiation chapters, whereby thematic clusters on fundamentals, of which the rule of law is one, has a central role. The chapters in this cluster are opened first and closed last. The methodological adjustments were prompted by concerns regarding the extent to which rule of law obligations had actually taken root in the acceding member states. Along the way, the Commission has repeatedly acknowledged the serious and often deteriorating rule of law situation in the aspiring member states. Similar to the internal rule of law critique, in the literature, the analysis on the lack of improvement in the rule of law in the candidate countries has emphasized mainly the lack of political will. For obvious reasons, the dimension of the lack of political will and ownership of reforms should not be discounted, and the fact that the Commission, in its later communication on the Western Balkans, departed from its usual more technocratic description to look beyond this, the democratic facade, is to be applauded. The argument proposed here, however, is that despite these concerns, the Commission has not significantly adjusted its understanding of the rule of law, sticking with its institutional checklist with a focus on the judicial sector, with roughly the same sub-elements presented in the accession rounds of 2014 until now. 2004 of the first accession. Analysis shows that these elements do not include the separation of powers, generally regarded as a crucial rule of law element. Even though the structure of the analysis of the political criteria of democracy and the rule of law in the annual reports follows the separation of powers rationale, there is a subdivision visible between Parliament, Executive and Judiciary. The analysis in each of these sections does not provide an assessment of the ways in which these branches interrelate or how their separation is organized in practice. leading to the conclusion that the Commission does not perceive the separation of powers per se as an element of the rule of law. And I think this is my final slide. Similar to the case of enlargement process, the enlargement process already mentioned, although perhaps within a shorter time frame regarding the internal rule of law, the EU has put forward a narrative in which there has been an emphasis on new tools to tackle the growing crisis. Also here, the EU institution acknowledged the seriousness of the deteriorating situation, albeit rather late. After all, only in 2019, the Commission still referred to circumstances in Poland and Hungary as challenges to the rule of law in some member states. The analysis of the rule of law elements in the internal toolbox also shows that, overall, from the older instruments of the Justice Scoreboard and the European Semester to the newer instruments of the annual rule of law reports, the emphasis has been on the functioning of the judicial sector in general and judicial independence in particular. In relation to the element of the separation of powers, there is, however, a noteworthy development. In 2019, the Commission issued a publication with a definition on the rule of law, which explicitly recognized the separation of powers as a core element in addition to the non-exhaustive list of elements of its 2004 communication shown before. The literature surmised that the explicit inclusion of this element might be connected to the reference of this principle in the post-2014 case law of the Court of Justice, as well as the nature of the attacks on the rule of law identified by the Commission in respect to the situation in Poland, which acknowledged several explicit breaches of the separation of powers. Be it as it may, the more recent EU documents on the issue have seen an increase in references to this element, with the Commission including it in its annual rule of law reports under the heading of Other Institutional Issues linked to checks and balances. Particularly against the background of the pre-accession process, it is promising to see the Commission pay more attention to this particular element of the rule of law. It is a truism that the success of reform depends less on technical or institutional measures than on leadership and changes in the values and attitudes of those in power, and that, thus, the rule of law reform should not be understood as merely technical. Accordingly, the inclusion of the separation of powers in its internal conceptualization of the rule of law could aid the Commission in bridging the gap between legal reform on the one hand, where it has competence to act, and the political will of the individual member states on the other, where it does not have the competence to act. Law and politics should stay in their own separate realms, especially to avoid political influence on the judiciary and on the enforcement and implementation of laws. This does not, however, imply that the rule of law should be devoid of elements concerned with the interrelationships between the three branches. After all, central features of the rule of law as a fundamental legal principle in the EU cannot be simply reduced to the empowerment of judiciaries. By properly including the separation of powers in its conceptualization of the rule of law, the EU will be better able to ensure its respect in the member states. Thank you.
Thank you very much, Lisa, for respecting the allocated time, and thank you for your most detailed presentation. And now the floor goes to Claude Prière. She's going to, like in the same line, she's going to, with a touch of solidarity, she's going to deal with the rule of law principle on the enlargement to the east from a different point of view, but in a similar line. Treat your neighbor as yourself, linking respect for the rule of law and protection of the Union's budget in the Western Balkans. Chloe, if I find your CD, Chloe is Director of the Center for European Law and Associate Professor of EU Law at the University de l'Université de Bruxelles. She was until October 2021 a postdoctoral research fellow funded by the Belgian National Fund for Scientific Research at the very same university. Her work addressed notably the cooperation in the EU of the EU with countries of Western Balkans in the context of the pre-accession policy. She holds a PhD in law delivered in September 2016 by the Université Libre de Bruxelles and the Université de Geneva. And she is an alumna of the Erasmus Mundus School Globalization, Doctoral School, Globalization, the EU and Multilateralism. Prior to her current position, she held positions at the Brugge University Brussels, the Dublin City University, and the United Nations Office of the UNODC, United Nations Office on Drugs and Crime. She assisted the coordination and co-authored several studies for the Fundamental Rights Agency within the European Union in 2020, and also on victims' rights, another one on violence against women from for the biannual period 2019 and 2020. Okay, thank you very much, Bria, for being here with Chloe, for being here with us, and the floor is yours. Thank you.
Thank you. Bring it closer so I can be sure to be heard. Thank you very much for this kind introduction, and thank you for the invitation. As it has been mentioned, the paper that I will present, with the challenge of being the last speaker of the morning just before the lunch break, actually builds upon elements that were presented partially in the previous two papers, and also echoes discussions that took place before. But what I want to look at is really to stress the importance of the respect for EU values and the rule of law for both EU member states and candidate countries. Indeed, it has been said already and stressed how much the respect for EU values is a fundamental premise of EU membership, as it is a basis that implies and justifies the existence of mutual trust within the EU. And what I want to look at, and you have to excuse me because it's one of my, I would say, hidden passion, the protection of EU financial interest, is the spending conditionality that has been developed that links the access to EU funds with respect for the rule of law. Just to present briefly this issue of spending conditionality, which is not something new, is a mechanism by which the EU and the EU institutions link the disbursements of EU funds with the fulfillment of certain conditions that aimed at pursuing various policy goals. It's a field that exists, and it's a mechanism that exists for a while, and that is not limited to the rule of law situation. But it is receiving an increasing academic attention over the last years, especially because of the evolution of the EU approach towards its own member states, especially, as I will see, relating to the rule of law conditionality for the access of EU funds. This form of conditionality can apply ex ante or ex post, meaning before or after the funds are disbursed. And it may apply in accordance with various objectives. Sometimes it's very broad objectives, like protection for the rule of law or democracy, as we will discuss. But sometimes it might be much more narrower specific policy goals. For instance, if I take the example of EU agricultural funds, it may be required that in order to receive EU funds, you have to ensure that there are environmental protection measures in your program. Here, I really like to focus on one specific form of conditionality, the one that establishes a link between the respect for the rule of law and the compliance with EU rules on financial controls, hence the PIF element. And the objective of this paper is to assess whether in the pre-accession policy the EU established a link between these two elements like it does now internally. So I will discuss a bit more the internal dimension with this new regulation that has been mentioned several times throughout the last days, but to see how this link has been established now internally towards the EU member state. And without surprise, the presentation will be divided in 2 points. First, analyzing what is this new regime of rule of law conditionality in relation to the disbursements of EU funds, and to examine how it compares with what exists in the framework of the pre-accession policy, and whether we find a similar connection between rule of law, protection of EU financial interest, and access to EU funds. And so my idea, and what I will try to do in the time that is allocated to me, is to compare these two elements, to identify whether there are differences and similarities between the two regimes, and whether one can be said to be harsher than the other. So I would just say a few words first on the new internal rule of law conditionality spending. I'm sure you're well aware of all the discussions and debates around this issue, but I will just simply summarize the new element, which is the adoption of this new regulation in 2020, introducing a general system of conditionality for the protection of the union budget. This instrument is particularly interesting as it was discussed, negotiated together with the new multi-annual financial framework for the current period until 2007, but also in relation with the next generation EU, this EU recovery plan to accompany states in recovering from the COVID-19 crisis. This instrument is interesting in the sense that it institutes a specific regime that aims at protect the union budgets when breaches of the rule of law principles have an impact on such protection of the union budget. And as it's been mentioned by the previous speaker, this instrument is perceived first as an element to complement the rule of law toolbox to counter the rule of law backsliding in some EU member states, with this idea that once political pressure, infringement proceedings or other forms of actions before the Court of Justice don't work, you go for the EU, for the money, and you try to have a mechanism that may eventually allow for the suspension of EU funds should the states fail to comply with the rule of law requirements. However, what I find interesting is that this instrument is also connected to an extensive set of rules relating to the protection of the EU budget and its financial interest. Those who have followed this field of EU law know that there exist already a lot of general and specific funding obligations relating to the prevention, detection and correction of irregularities and fraud. And the EU has even set a specialized actor like OLAF for the EPPO to support its efforts in making sure that when EU money is disbursed, it's employed correctly and it's not diverted, embezzled or used for political ambitions. What is interesting is that even before the adoption of this rule of law conditionality regulation, there are some forms of conditionality that can be found in the general PIF instruments. For instance, in the Common Provisions Regulation that I had the pleasure to read before coming here, which apply for most of the main EU funds, the Regional Development Fund and other European Social Fund equally. There you have, for instance, a general provision that states that when implementing this regulation and implementing the funds, the member states and the EU institution must ensure the respect for fundamental rights and compliance with the Charter, which allows eventually building on the precise case law of the Court of Justice, identifying precise obligations, for instance, on the basis of Article 19 TEU or Article 47 of the Charter, to maybe eventually use this kind of provisions eventually as a ground for determining whether access to the funds is possible. Similarly, as it was discussed a bit earlier in the first panel of the morning, there is also possibility under this financial PIF instruments to apply a form of ex post spending conditionality, which means that after the money has been spent, the recipients are subjected to specific obligations, either as member states or as natural or private or legal persons, to comply with the prevention of fraud and irregularities, notably by accepting OLAF investigations and being eventually subject to administrative sanctions that may lead sometimes either to the suspension of payments or the obligation to reimburse the funds that have been attributed. Yet, there was a need, a feel that this new regulation on budgetary conditionality was needed, and I like just briefly to highlight some of its, I would say, added value. It does include a definition of the rule of law, building on what exists in the case law of the Court of Justice. The definition in itself has been attacked by Hungary and Poland in their annulment actions before the Court of Justice, but still, has it been mentioned also by the previous speaker, the court accepted this definition as a valid one that sets an obligation as to the results to be achieved on the part of the member states, and framed very carefully the fact that this definition is intended solely for the purpose of that regulation. Nevertheless, The added value of the regulation is not solely based on that. It's the fact that it has a transversal scope of application that may apply to all the EU general budget under the current multi-annual financial framework, but also the Resilience and Recovery Fund, which is like the big source of transfer of money from the EU to the member states under the current context. And the regulation really tries to propose a mechanism through which, when particular breaches of the rule of law affect or risk affecting the EU financial interest, there is a possibility for the Commission to propose gradual measures that may lead eventually to the suspension of payments. But, and I think that's one of the main aspects here, is that this possibility to use the regulation is limited to situations where these breaches of the rule of law are strictly or sufficiently directly linked with the breach of, with the effect they may have on the EU financial interest. To say it in more layman terms, it's the idea that you could have breaches of principles of rule of law. Let's think, for instance, on attacks on, I don't know, freedom of expression or freedom of the press. If these elements do not have a link with the protection of the EU financial interest, they may not be sufficient to activate the regulation, which was one of the points of criticism for this text, that it's limited to situations where the breach of the principles of rule of law have an effect on the EU budget. But still, we see that the spending conditionality is present and really aims to ensure that if the situation deteriorates in a member state, there is a possibility eventually to block funds and to use the regulation to suspend eventually the access to EU funds. Turning now to the external rule of law spending conditionality, I focused on the Western Balkans. As it's been said, this region is subjected to a regime where you have at the same time a general framework, the stabilization and association process, but still with a differentiation between each country depending on its progress and its I would say, its willingness to answer the EU demands. As it has been said also before, the difficulty with this mechanism is that the level of expectations and I would say the threshold to be met is changing throughout time, and the requirements that have to be satisfied by these countries are not firmly set. The negotiations and the discussion regarding their accession started in the early 2000s. We are almost 20 years later, and we see that the methodology, as it's been discussed, and as I will discuss in a moment, is still evolving and adapting, making the, I would say, the idea of accession still something a bit looming in the distant future without any clear and precise deadlines. The rule of law conditionality applies vis-à-vis these countries through different ways. I won't come back to the general conditionality, has been discussed already, but you are aware of the existence of this political criteria that impose respect for the rule of law as a precondition for advancing toward accession. It's repeated in more, I would say, specific instruments, such as the stabilization and association agreements, for which the rule of law is among one of the essential elements that underline the application of these agreements. And what I found interesting is that still, when looking at the details of these instruments, you see somehow beyond the, I would say, standard benchmark or the content of rule of law as understood and promoted by the EU and the Commission in the context of the pre-accession policy, independence of the justice, fight against corruption, etc. Some element that echo to the protection of EU financial interest. For instance, via the obligation of these countries to participate in administrative cooperation mechanism, for instance, with EU actors, and the definition of specific objectives that mobilize sometimes international law instruments sometimes pinning down to precise obligations that are linked both to the respect for the rule of law and the protection of the EU financial interest. I think here, for instance, of the need to, for instance, fight against corruption, which can be perceived through different ways. With the reform of the accession methodology that has been mentioned already several times, we see that things are changing with this emphasis on fundamentals chapters, where you find I would say, the classic chapters on like linked to the rule of law, those addressing the judiciary and fundamental rights, and those addressing justice, freedom, and security, where you find as well provisions relating to the independence of the judiciary. But you have also the instrument on financial control, which means that the Commission will monitor how the Western Balkans countries that are engaged in collaboration and cooperation with the EU, how they do ensure themselves the protection of EU financial interest and the protection of public expenses more generally in avoiding corruption, embezzlement, or misappropriation of public funds. And the spending conditionality is also very much present with the instrument for pre-accession assistance that was mentioned by Elisabeth a bit earlier. This instrument is really like the main instrument that is used to channel EU funds to the Western Balkans countries. And we see a bit of rule of law conditionality in its operation. I pinned down like one or two provisions, some relating, I would say, to the general assessment, a general appreciation as to whether the access to funds may or may not be modulated depending on the country's willingness to respect the rule of law and other key principles. This is, for instance, reflected in the latest version of the regulation organizing this instrument. That does mention the fact that the EU institution, in particular the Commission, will adopt a performance-based approach, taking into account the efforts made by the countries in the fields of the rule of law and fundamental rights, and that in case of significant regression of lack of progress, the scope and the intensity of the assistance may be modulated or redirected. This is a first element of this kind of, I would say, general conditionality that may take place ex ante before the money is transferred to these countries, taking into account what is the situation, what is the respect for this principle before the money is allocated. However, you have still very much detailed obligations that are linked to the protection of the EU financial interest. Indeed, the instrument for pre-accession assistance, like other EU funds, is subjected to this financial regulation that was mentioned also earlier this morning, where there are as well strict obligations, notably to detect and eventually report irregularities, which may lead to the interruption and the suspension of funds should the conditions not be fulfilled. And you have, again, elements that are building on the existence of strong I would say legal framework and legal regime internally, as it is foreseen within the EU member states. The cooperation with the specialized EU actors, the OLAF and the EPO, is also envisaged as a way to ensure that ex post, once the money has been disbursed, the EU financial interests are still respected. But here, and really that's one of the main aspect, is that we see that the link that is made internally between the breaches of the rule of law that may impact the EU financial interest here are not necessarily made so explicit, and that's one of the main, I would say, difference of the comparison of the two regimes. Indeed, like we see that the spending conditionality applies in both instances. Both like before and after the money is disbursed. We see it, for instance, at the moment with the discussion regarding the approval by the Commission of the recovery plan for Poland and Hungary, which is still pending, even though the plans have been, I think, notified to the Commission, I think, in June 2021. And the regime foreseen under the instrument for pre-accession, this idea that before the money is disbursed, you have an overall assessment as to whether rule of law is complied with. Similarly, when looking at what happens once the money has been disbursed, the regime regarding the protection of EU financial interest is very close. Cooperation with OLAF and the EPPO is like a standard element, as well as the obligation for national authorities to detect and report irregularities and fraud. However, and I will finish because I see that my time is almost up, there is one important difference, is that for the EU member states, really the way the regulation is framed, this requirement of a direct link between the breach of the rule of law and the impact of the EU budget is very much receives a strong emphasis, as well in the regulation and in the judgments of the Court of Justice. And any possible suspension of the funds is subjected to a very specific procedure. You may have read about it, involving the Council of the EU, which may take a decision that might be subjected to a judicial review by the Court of Justice of the EU. However, for candidate countries, not only this link is not so strong, but the conditionality based on the rule of law is based on much broader consideration, and the procedure is less transparent in the sense that it's decisions that are taken not only on the basis of precise evaluations, but also depend very much on political consideration. And that's where what I want to conclude on, which is, I think, echoes as well the limits that have been pinpointed before, is that for the promotion of the rule of law, the use of spending conditionality has potential. However, the activation of this mechanism depends very much on, I would say, political sensitive discussions and the support of the EU member states. We saw it for the adoption of the regulation, where there was a need to have a special compromise within the European Council to obtain support for its adoption. Or the fact that at the moment there are discussions as whether the Commission might be pushing away the possible activation of the regulation against Poland and Hungary due to the international situation. And it is the same regarding Western Balkans country. The role of the member states has been reinforced with the new methodology. They are more actively involved, and still the nationalization, the needs for unanimity remain strong. And that's where strict budgetary conditionality, the PIF, I would say, may present a certain advantage, as it is a kind of strong legal framework that is a bit more shielded from such political consideration, even though budgetary conditionality can be used to address sometimes elements that are part of this rule of law contestation and rule of law backsliding. There is the example of the LGBT-free zones town in Poland who applied for EU funding but were not selected for specific funds. That is a form of applying rule of law conditionality ex ante. But you also have cases where the instruments are used to make sure that, for instance, if EU funds are diverted or embezzled or misappropriated, the obligations under the protection of the EU financial interest may serve to rectify the situation, and the independent EU actors may play a role in addressing some of the violations. And so I think that's maybe an easier technique to ensure a stronger conditionality going through the protection of EU financial interest. But I'm looking forward to your questions and the discussions, and I hope you followed me despite the technical discussion.
Thank you very much, Chloe, for this enriching presentation, and thank you for the three presentations we've heard in this roundtable. We have shown, the speakers have shown the very European feature of being so able, so capable of doing self-criticism, because here we have been very strict towards the methodological vices of the Commission's approach to this issue, and instead of falling in the easy arms of self-satisfaction. So thank you so much for pinpointing those details, those elements. And now the floor is open to anyone in the audience, please.
Well, thank you very much to all the panelists, and I apologize in advance for my non-existent voice. This question goes to Professor Reith, but also to Professor Birrière, if it's possible. We have several in the European Union instruments to promote democracy and rule of law in your neighborhood and candidate countries. We have the IPA, as you mentioned. But we also have, in collaboration with other stakeholders like the Council of Europe, we have the horizontal facility that we use to promote and improve rule of law. We have already done technical assistance. We have done sharing good management and practices with bodies and national bodies and governments, aside from, of course, providing money. Professor Ritz mentioned that there might be a needed evolution on the EU values that we are promoting, if I didn't get wrong. And my question is, towards what direction should we aim? What are we missing? And in the sense of, for example, the institutions lacking maybe something else in the area of promoting rule of law, what do you think that the institutions should implement in the future to improve in this area? Thank you.
I think we can take a couple of questions if there is another one, please.
Good morning. I would like maybe to give some answer to that question, and what the position I want to make is based on not only the academic approach, but also the experience that I'm carrying on my job. I have visited Strasbourg in 3 occasions in a seminar, international seminar done by a School of Human Rights that is held in Strasbourg for many years, since 50 years ago, followed by a dream that René Cassin, after he got the Nobel Prize, he met students from all over the world. He made them for a month in Strasbourg. It means like you put them into a room, make everybody's approach to human rights or to rule of law and experiences, make all of them to share the values, in the sense that first week they were teach universal human rights, or the system. After that, the European system, the African system, Arab system, and in many occasions what is done in the corridors, sometimes it is the more important. Of course, the money is important, but it's the relationship of all those experiences they are made with people from different approach. Sometimes it was absolutely amazing to see African judges for a month discussing with the European judges for a month. So I think that is, of course, the money is important. Of course, this foundation approach and bringing students, lawyers, diplomats, because it's not only one only side, it's many sense. So my question is, use the money wisely, check what the money, what do you do with the money, but take or give them to NGOs, foundations, and diplomacy, because I must say, is like, what I think is like, is the holistic way of promoting the rule of law, what on my occasion, on my point of view, so that my experience, and I've visited this school since 15 years ago, and after 10 years ago, and still keep in contact with all those people from the Arab world that at the beginning they were just students. You contact them 10 years after that, and you see the big difference. And also made an experience that work in airlines, and you see that it's not, sometimes we can become too much academic or too much diplomatic. We are on the top, but sometimes the values have to come to the common size. So well, I'm sorry for the extension of my question, of my approach.
Okay, I found that's the common, not a specific question.
Yes, that do you think the European Union, or don't you think the European Union should use the same way it's done with cooperation with the humanitarian work? Should it be focused a little bit more on the job made by the NGOs and
So we have a couple of questions to be answered now.
Yes.
Lisa, please feel free to intervene also if you wish. So online we can hear you right?
Intervention.
And
A comment.
we'll have 2 questions and then we will do a second round. Is that okay for you? Thank you so much. Please. Any one of you wishing to be the first?
Okay. So thank you very much for the question. I will also allow Luigi, after I finish, if he wants to add something on this, because it is actually the question that was asked, this reflection that we were having at the end of our research, saying, okay, this is not working, so what do we do? You know, so our question was a little bit on, but are the criteria that the European Union tries to, you know, the toolbox that it has on what the rule of law should be, is it something that is actually exportable towards its neighbors? Or is it just a matter of the methodology, or is it a matter of the notion itself of the rule of law? And so that was our reflection. Of course, the answer is very difficult, because if you decide that the rule of law is a European Union concept that cannot be exported, then you have a problem, because it means that you cannot export it anymore, and therefore that either you accept to enlarge the European Union towards countries that do not support this concept, or you continue imposing a checklist that will actually never be reached, and therefore you fall on what Chloe was showing through one of her images of a never-ending procedure of accession. So I don't think I have like an absolute answer for this, because it is indeed also the open question that we had at the end of our research. But maybe Luigi would want, I don't know if he can intervene, but he's supposed to be connected. Yeah.
I can yes, but I don't think that there is much.
Yeah, maybe just briefly, like to follow on the discussion. I think, like, besides the techniques and the content, I think one thing that the EU is doing and could do more is and it's here the limits of its European standards, that the EU is also mobilizing other instruments. And when I think about the Western Balkans country, or but the neighborhood, like the Eastern neighborhood policy, most of the countries are part of the Council of Europe, and you see it in the way the EU promotes the rule of law. It's not in isolation from other instruments that exist in other legal frameworks. The Council of Europe Convention are frequently mobilized, same for some of the UN Convention, and clearly it's specific obligations that are not the rule of law as a broad principle, but still I think they can help to, for instance, like support the fight against organized crime, against corruption, or even to ensure like good judicial cooperation between authorities. And I think it's something that is important, because I think it builds also on this kind of socialization element that you mentioned in your comment, that when the EU, or like when the EU Commission arrives in these countries, it does not come alone. Especially for the Western Balkans countries, like it goes with Council of Europe delegation, OSCE delegation, UN delegation, and other partners that are coming together, addressing sometimes, I would say, coherent demands to these countries, like to accede to a specific convention, to implement some obligations. Still, I agree with the remark you made earlier. It's very much sometimes a stabilocracy, that you have the law that is adopted to transpose these international obligations, and then the practical implementation, it's lacking, and it's not necessarily followed in practice. And I just wanted to refer to the comments that were made about the need to support civil society. Like in these EU funds that are set up, civil society organizations are very often direct recipients of grants. And the thing that is interesting is when you look at the mechanism that may eventually suspend funds if the country in question does not respect rule of law, or does not protect sufficiently the EU financial interest, is that in the answer that is brought to these questions, to these situations, when I mentioned the IPA and the fact that the assistance may be modulated or redirected, there is an idea that, for instance, rather than suspending the fund, I would say in a blunt way to all the recipients located in the country, the fund might be suspended for national, like governmental public authorities, but the NGOs funds, which is a different strand, is protected and like taken independently to make sure that, for instance, support to civil society organizations that support the rule of law in these countries are not cut from funds when they are in fact contributing to hold the government accountable and helping I would say the EU to maintain a certain pressure. So it's something that is taken into account in the way the funds are also managed and disbursed, and there is an attention paid to make sure that civil society organizations are not impacted because of the misbehavior of the national authorities. That's a tough question.
Okay, Lisa, would you like to add something?
Yeah, thank you. As far as I've understood, because I have the similar problem to Luigi, is it's a bit difficult to understand you guys from the floor, is that the question is about rule of law effectiveness in external relations. How can we improve on that? There is a host of particularly American literature that deals with those questions, and that has kind of trickled down also at the European level. And one of the things is that if you wish to actually look at how the rule of law is actually implemented rather than how it is on paper, or how it is, like I also called it, the more quantitative approach, if you can just tick the box and say, okay, I've implemented these regulations, I've implemented the EU acquis, but does it actually work? And is it actually coherent? And does it work for my state? Is what the literature mainly points out, is that it is if you look at the rule of law, the people that are involved are lawyers. And what do they look at? And this is the bottom line, they look at the legal sector. And if you look at only the legal sector, you will not get there. So what they kind of promote is that you have to have a more so-called ends-based approach rather than an institutional approach. You have to look at what is it that you would like the rule of law to do, and rather than what does a court need to look like? Do we need to have a constitutional court? Had to mention like a few basic things. And of course also because what you see in enlargement, and particularly in the earlier rounds, is because the states have come from a more communist background, there was a lot of state building to do, which automatically puts an emphasis on the institution. So particularly in enlargement, that really kind of those things reinforce the more institutional approach, rather than actually looking at the rule of law and saying, okay, what is it that we actually need, and what does it need to do? And as I also said, I think it's important that the rule of law does look also at political elements. It is about, the rule of law is not technical. It is about taking away power from people that might have had it before. And how do you deal with that? And how do you ensure that they then stick to it?
Thank you very much, Lisa. I think we can steal a couple of minutes from lunchtime to have a pending question there. 3? Okay.
Thank you so much.
Please try to be brief so that we can have the feedback briefly also.
Thank you so much for the presentation. My intervention is more a comment than a question on the presentation of Elizabeth on the EU rule of law obligation in third countries. And I would like to give the example of Togo. Togo is my country located in West Africa, and the EU imposed rule of law implementation there twice in the history. First in 1993 and the second time in 1998. by suspending the cooperation with the country due to the dictatorship of the then President Eyadema, violating human rights and corruption in administration. And what did he do? That president was always pushing people to civil riots and things that are not democratic at all. And the EU decided to call upon other partners to development of the country to leave the country. They suspended the financial aid, and this also means the withdrawal of foreign investors in our country. So the country faced a very dire economic situation in that time, on the verge of collapse because of that cooperation suspension. And the leaders at that time felt compelled to organize democratic election. In 2007, yes, they organized parliamentary elections, and the election were deemed democratic by the EU observers. And finally, they resumed the cooperation. By this cooperation resumption, the country have now partners from the EU and from other countries, United States, that are helping my country. And today we can say the EU played a very important role at the very beginning of the democratization process in African countries, especially in Togo. That's what I would like to add, to say that, yes, the impact assessment is positive. The situation is not perfect currently, but there is still a lot to do. But we could say that what we witnessed in the past is very hard, and now we can move forward with the help of the EU. Thank you.
Thank you very much. We pass to another question, and briefly, please, so that we can have the last feedback from the table. Down there.
Well, thank you very much. It was a very interesting panel. I'll be straightforward. Do you think the rule of law can be promoted in third countries located farther than in the EU neighborhood? Or to the contrary, it actually depends on the political power of the Union? And that's precisely why the promotion stays closer to our borders. If so, could the negative results of the EU's current actions, like for example in Tunisia, be the reflection of the impossibility for the EU to become a globally recognized normative power? Thank you.
Thank you. And the last question here, please.
Yes, I was no microphone. So, well, Lisa mentioned that the European Union is...
I think it's better if you use it just for the people. They can't hear you otherwise.
Okay, Lisa, so you mentioned that the European Union is allowing less national variations in its enlargement policy, while in the European Union, so internally, it does allow variations regarding the rule of law. Yeah, exactly. So my question would be, and also the other speakers can also comment on that if they want so should the European Union, because I think that all the problems that we have faced regarding Hungary and Poland contact in the last few years, and this year and last year, of course, regarding the promotion of rule of law, I think that this has made us stricter with the promotion of rule of law, both in its internal policy and its external policy in the enlargement policy. Thank you.
Thank you. So, briefly from the table. Which one of you wishes to start?
Maybe I will this time first. Luigi, do you want to first say something, and then I can add on you if you want? On the promotion of the rule of law farther than the EU neighborhood?
We have 5 minutes more, that's all.
About the promotion of the rule of law outside the EU neighborhood.
Yes.
The question is whether the EU can promote the rule of law outside the EU neighborhood. Well, it can it should, arguably, it is bound by constitutional commitments to do so, Article 3.5, the EU, also outside of the EU neighborhood. Can it do so? It has tried. That's why it adopted restrictive measures against Venezuela that were mentioned earlier this morning. Is it more successful? My guess would be that it is that there is a reverse correlation with distance. The farther away the EU tries to act, the more difficult it is that it carries weight. So the instruments that it has for the neighborhood, as we have heard, are, I think, sharper, politically more appealing than the ones that it has for reaching farther away regions.
Thank you. Very briefly, anyone else?
Sorry. Just to add, maybe I think, like in link with that, I think it depends also of other factors, like the economic imbalance sometimes that you have with some countries that are dependent on the EU for their trade, for instance. And I think the capacity of the EU to promote the rule of law further away may use different mechanism. But again, as it was mentioned, I think the particularities of the countries of the neighborhood is that it's not just the accession that is the incentive that you can mobilize visa liberalization measures. You have other instruments that are more short-term that you can use a bit, I would say, to give further incentive to the countries in question to promote the rule of law. But for more distant countries, I think it depends on their relations with the EU, whether they depend on it for trade, for instance. And I think that would be discussed partially in the next panel. So you have maybe more discussions later.
Thank you very much, Lisa. Any last word on your side?
Yeah, thank you. I'll try and be brief. I think it is more a question of the internal capacity of the Commission to actually understand and truly analyze the situation of the rule of law on the ground in a particular country, and this goes to the member states as well as to acceding states. That is the very brief answer. I think that for various reasons, this whole trend towards a more uniform approach in the rule of law in enlargement was also fed, for example, by information from the Venice Commission, which advised to indeed implement judicial councils, even though the member states don't have them, for various reasons also related to the state of play of the acceding states, where they were in their development. What you see, however, is that this tendency for a more uniform approach rather than differentiation is now also trickling down into the instrument for the internal conceptualization of the rule of law. And as we've seen, the court has really emphasized the necessity of having national variations in your own national system and build-up of your rule of law system. Thus, to my mind, it rather becomes also a question of is the Commission truly equipped to really look at this in depth and to really understand the interaction of all the elements together, because this is what the rule of law is about. As a flexible concept, you basically have a duty of an obligation of result. How you get there, okay, there are some common elements. There is a baseline of what needs to be there. But how they interrelate is basically more important to my mind than having the exact elements or having specific elements.
Okay, thank you very much. Thank you very much, Lisa, Luigi, Elizabeth, and Chloe, and to the audience also for your patience. Thank you. Perdona, Luis, que me toma la libertad.
Todo lo contrario, magnífico. We begin this afternoon at 2:15 p.m. 2:15 p.m.
Que como hemos
Thank you.
empezado un pelín tarde, pues...
Yo pensaba que te lo había dicho que Lisa lo estaba...
Yo no lo sabía, estaba diciendo y me falta
Good afternoon. Good afternoon to everybody here in the room, and of course to those who are connected online. It's a great honor to be here to chair this last round table. That it's a kind of end of the work that we have developed during 1 day and a half. First of all, I would like to thank the organizing committee, in general the University of Granada and the ESIL group for inviting me to chair this last table. I'm very pleased to introduce the speakers. Well, as you know, there was another professor, Professor Caduz, that unfortunately she couldn't come due to some problems, and but we will try to have an excellent presentation and discussion with the two speakers here. Well, to make the last reflection or analysis about the conditionality in the European Union external action, I'm pleased to introduce Professor Gloria Fernandez Arribas. She holds, on my left, she holds a PhD in law from the University Pablo de Olavide in Seville, a master's degree in international public law from the University of Leiden. Her work is focused both on issues of public international law and European law, as we are going to see immediately in her presentation. As part of her research activity, she has spent time at various universities and research centres abroad, as Robert Schuman University, University of Twente, King's College London, Fordham University, Asser Institute, and Leiden University. She has also participated in conferences, seminars, and courses in Spain. Finally, this research work has been compensated by different awards. We can mention, of course, as she was a PhD candidate, the Extraordinary Doctorate Prize of the Pablo de Olavide University, and later the Andalusian Prize for Research on European Integration, that usually it's held and organized from this University of Granada in the Andalusian community. Well, she is going to talk about the principle of non-intervention and the European Union promotion of human rights and democracy. You have the floor, Professor Arribas.
Thank you. Thank you, Carmen. First I would like to thank you also, Professors Pérez Bernardez and Hinojosa for the invitation, and to thank the organizers for efforts they made in organizing this conference. My presentation is linked with that of Professor Wessel yesterday. Thank you, by the way, Wessel, for raising expectations of my presentation, no pressure. I will be focusing on the link between the principle of non-intervention and the measures adopted by the European Union to promote human rights and democracy. Because as it was discussed yesterday and also today, there are two legal dimensions on this European Union activity, the internal and the external dimension, or the European law and international law dimensions. And for example, sanctions may comply with EU law, but maybe not with international law, or the other way around. And I will focus on the external dimension, specifically on the principle of non-intervention, and regarding the promotion of human rights and democracy. So, as you know, one of the main problems regarding the principle of non-intervention is that there is no clear definition of this principle, and also that we can find different practice among states. And since there is no, for example, definition in the United Nations Charter about the principle of non-intervention, First common approach to the concept of non-intervention is that of Resolution 2625, which established that no state or group of states has the right to intervene directly or indirectly for any reason whatever in the internal or external affairs of any other state. However, considering that the definition in these resolutions and other resolutions are not sufficient enough to clearly determine the content of the principle of non-intervention, scholars have considered the International Court of Justice definition in the Nicaragua case as highly authoritative, establishing the elements of any act of intervention and being the main one, as you know, coercion. Nevertheless, the concept of coercion can also be object of different interpretations for cases not involving the use of force. And for example, what does economic coercion mean, or what does political coercion mean, actually? In this respect, the European Union recently adopted a draft regulation to protect the European Union and member states from economic coercion by third countries. This regulation allows us to determine how the European Union understands the concept of coercion and its way of action. And according to this draft regulation, coercion can be, has been defined as cases in which a third state interferes in the legitimate sovereign choices of the Union or a member state by seeking to prevent or obtain cessation, modification, or adoption of a particular act by the European Union or a member state, and by applying or threatening to apply measures affecting trade or investment. So this is a general definition, and this definition has been put into context with references to a list of elements that must be considered when determining the existence of an act of coercion, among which is included whether the third country is acting based on a legitimate concern that is internationally recognized. This element may be considered significant when analyzing the European Union's promotion of human rights and democracy through the adoption of sanctions or other measures, since it states that those measures adopted by the European Union could be justified if human rights and democracy are considered subjects of international concern. In addition, the draft regulation also established that coercion is prohibited under international law when a country deploys measures such as trade or investment restrictions in order to obtain from another country an action or inaction which that country is not internationally obliged to perform and which falls within its sovereignty. In this context, therefore, are human rights and democracy international obligations binding states and allowing the European Union to adopt coercive measures to promote or impose them? As you know, human rights today have come to limit the state's domestic jurisdiction. And in this regard, even if during the third quarter of the 20th century, some states were reluctant to admit that or admit an international role in the protection of human rights, especially Soviet Union, Asian states, or developing countries, it was admitted, at least during the last quarter of the 20th century, we don't know if until today, that not only do international human rights institutions have a role in their protection, but so does the international community as a whole in the protection of human rights. Therefore, since criticism regarding human rights violation cannot be considered an intervention in the internal affairs today, pressure to comply with human rights obligations that may constitute acts of intervention in the past are accepted also today. On this subject, the European Union has played an important international role as part of its mandate, And in addition, the European Union adopted the European Union Action Plan on Human Rights and Democracy that was explained yesterday. And this plan established a new global European sanctions regime for human rights violation, and also contained a list of European Union instruments for promoting human rights and democracy. Regarding human rights, two main instruments in which action could cross maybe the red line of intervention have been adopted by the European Union: restrictive measures and conditionality in international agreement. We have also talked today about that. For example, in the framework of the Cotonou Agreement, the European Union decided in 2016 to suspend financial support and funds directly benefiting the Burundian administration or institutions, with the purpose of forcing the state to comply with human rights. If we take into consideration the definition of non-intervention included in Resolution 2625, we can see a link between these measures and the definition, since the resolution refers expressly to the prohibition of the use of economic measures to coerce another state. On the other hand, it is true that in the Nicaragua judgment, the International Court of Justice did not consider the economic measures adopted by the United States as a violation of the principle of non-intervention. It has been said that the court seems to distinguish between measures that are inherently lawful and used to influence the behavior of a state, and unlawful measures such, for example, a trade embargo. Therefore, and regarding this measure of the Cotonou Agreement, to adopt negative measures included in an international agreement, as the Cotonou Agreement, could be considered among those inherently lawful, since they are already included in a treaty agreed by the parties, and therefore will not constitute coercion, not the violation of the principle of non-intervention. Also, the European Union has adopted restrictive measures against third states and individuals because of human rights violation, and the more recent controversies, for example, involving Russia and China. In March 2021, the European Union adopted sanctions against Chinese officials because of human rights violation of the Uyghurs Muslim minority. The Chinese government's response was to consider these sanctions a gross interference in China's internal affairs. In the same vein, the European Union adopted targeted sanctions against Russian officials because of their participation in the persecution of the opposition leader Navalny and because of human rights violation. Russia had already declared that the previous restrictive measures adopted against Russian nationals accused of participating in Navalny's poisoning violated the Helsinki principle of non-intervention in internal affairs. Together with these measures, the European Union has also adopted restrictive measures against Libyan, North Korean, Burmese, South Sudanese, or Chechen nationals because of human rights violations. In the latter case, for example, because of the repression of lesbian, gay, bisexual, transgender, and intersex persons, increasing, therefore, the right to be protected by the European Union abroad. Returning to the question regarding the inherent lawfulness of the measures adopted by the European Union, in this kind of measures, I think it is possible to affirm that, for example, the asset freezing and the restriction of entrance and transit do not entail, from a first sight, a violation of any international obligation. In this regard, the right to property, that has been considered a human right even, can be limited in public interest and provided by law, as can be the case of asset freezing. And regarding the restrictions of entrance and transit, the Council decisions establishes as an exception the cases in which a member state is bound by an obligation under international law. Therefore, the sanctions the European Union adopted against national or third state in order to make a state comply with human rights could be considered as well inherently lawful, non-entailing an act of coercion according to the interpretation given by the International Court of Justice in Nicaragua. Finally, and regarding embargoes, those adopted by the European Union, there are those adopted under the framework of the United Nations Security Council, as in the case of North Korea, Afghanistan, Yemen, Somalia, or Libya. And those must be considered legal. They have the support of the Security Council. But on the other hand, regarding embargoes not adopted within the framework of a Security Council resolution, as in the case of Iran, Burma, Zimbabwe, or Venezuela, the embargoes refer to goods or materials used for human rights violations, for example, arms. It could therefore be justified in the case of the aforementioned statement. The respect of human rights can no longer be considered an internal affair, and actions to make a state comply with it are no longer an intervention in the internal affairs. This is regarding human rights. And regarding democracy, the situation is different. Since Frank's paper in the 19th of the emerging right of democratic governance, many studies